Appeal from
the order of the appellate court bill.
when the order was passed.
2nd of December.
Have you applied for certified copy?
Yes.
Have you annexed that
Yes.
photocopy of that application?
Yes.
My lord, may I be permitted to mention one matter, my lord, under compelling circumstances. On 4th of December, my lord, I have filed caveat. My lord, একটু দেবেন তো জজ সাহেবকে? On my lord 8th, one ex parte order was my lord obtained by the my lord other side without serving any notice, my lord, to me. My lord, on yesterday only at 2 p.m., the trial court's my lord advocate told me that this order was passed, no copy has been served, nothing else. Neither any my lord forwarding letter. My lord, they have already.
The matter has to be mentioned.
That matter in respect of that marriage. On 15 days.
My lord, entire path. Entire my egress and egress already my lord flow.
I'm telling
You
you.
know,
I'm telling
you
I'm
know
telling-
the judgment.
I'm
You
telling
know the judgment of our High Court, division bench presided over by Justice Hon'ble Kumar Sen, that if there is a caveat and if the service has not been affected, then in that event the order should not remain.
My lord,
Let it appear tomorrow.
Yesterday
as
I
to
have
be
my lord
mentioned.
intimated me.
Whatever you want to say it tomorrow.
And my
Not
lord,
to be
full
mentioned.
they are completing the pandal.
Come with the judgment of Justice
My
Hon'ble
lord.
Kumar Sen. Come with that.
My lord, may I have your
Please,
lordship's
lordship.
leave to mention one contempt application? Lord, this matter
Our
was
order?
My lord,
Our order,
my lord, my lord,
Both
this
of
matter
us?
was running in the list.
both of us pass the order.
Yes, my lord.
I permit to mention under order 41 rule 11.
উনি তো বললেন যে আমি annex করেছি। I asked. Please, না হলে ফেরত দাও। ওটা annex না করলে হবে না।
My lord, may I have my lord's kind leave to mention under order 41 rule 11 matter for inclusion.
Lordship, on matter is for non-prosecution. Lordship.
Oh, always welcome. Give.
Lordship, I'm praying for admission of an appeal, inclusion in the list.
Appeal,
Oh.
madam. Page.
Order 41, Rule 11.
Give.
Sir, may be permitted to mention one application.
Give.
Thank you. Much obliged.
But in regard to item number 5, my client has already vacated the.
Let it be called.
In this matter, I am for the respondent, my lord, praying for extension of the interim order which your lordships passed on,
Respondent is praying for an interim order.
my lord, because execution, the appellants have. Sorry, my lord. I am for the appellant and
the
stay of execution.
Come on the side of
Yes,
the.
my lord. Stay of execution proceeding. I am for the dependent appellant, my lord. I have served, my lord. The private respondent, sorry, only the one respondent is there. I have served him. And I have also communicated the. My lord, in the same address, when I served the application, my lord, it was accepted. Now it has returned as left.
What about the advocate?
My lord, I have served. And that letter, through the learned advocate of the trial court of the defendant, my lord, he tried to serve it to the learned advocate for the plaintiff, but he refused to accept that.
Have you written that?
No, my lord, I came to know later on. Yesterday only I came to know.
Then you'll have to write.
My lord, then I'll file in the course of that.
Supplementary affidavit you filed come at 2 p.m.
My lord.
Because our order was.
ওটা একটু দিয়ে দিন না আমাকে
The advocate possession of executed court by hand. You have to say in affidavit that he refused to accept.
আরেকটা
Come at 2.
My lord, these are my applications. Two applications are here, my lord. One is
There are many applications.
can number
Up to
6.
7.
Can number 6 is a section 5 application, and can number 7 is the parent application where I am seeking for recalling of an order dated 3rd August 2012, which was passed by my lord Justice Shubhra Kamal Mukherjee and my lord Justice Tandon. And my lord, my ground for
civil matter.
Yes, my lord. This was a appeal from a decree which was withdrawn because the matter was amicably settled. My lord, the issue was Thika tenancy. The eviction suit was dismissed because
Other side,
My lord, I am appearing for the appellant numbers 2 to 4.
yes,
If your lordship recalls, this application is by the appellant
One of the
number 1.
appellant number one.
1.
All the appellants were represented by a common lawyer.
Common
yes, my,
advocate.
therefore we have taken
It was-
change and we have filed this application.
What is the order?
My lord, takes page 20 of can number 7. I'm sorry, my lord, page 16, 3rd August 2012.
The matter has been disposed of.
The appeal was allowed, dismissed as withdrawn.
Now he wanted to recall that order.
One of the appellants is wanting to recall.
Because, my lord, the
Okay.
fact,
Where is the written instruction?
my lord,
Written instruction was there on that day,
my lord, that
which was directed to be tagged with the record. Difficult. একটা চিঠি আছে এটা না না চিঠিটা কোথায় আছে? Oh, this is the your name?
my
What's your
lord,
name?
Sanjay Saraf.
You were signatory to that application.
Yes, my lord.
You
My
were
lord, my
signatory
fact,
to that letter.
Huh.
Second. Who is the advocate and record here?
my lord, Mr. Devanshu Dinda, in my, upon me. We have taken a change on 2nd of February 2023 because, my lord, will recall earlier, my lord, in 2022, we had filed an application without, the change was not taken at the point of time. Thereafter, my lord, that application was withdrawn and with liberty to file afresh, we have filed. Then on February 23, we filed this application.
So what is your
My lord, the ground is very simple. My lord, the issue was Thika tenancy, eviction
I
suit
am
was,
asking you very simple question. There was a letter which was written by all the appellants, including you,
yes, my lord.
signifying your intention that you do not want to proceed with the appeal and the appeal be dismissed for non-prosecution. On the basis of that letter, the court recorded that the appeal be dismissed as not pressed.
Yes, my lord.
So now you wanted to recall that order. Now, two things is there, that what prompted you or constrained you to sign on this particular letter? Are you denying the signature of this?
No, no,
letter?
no, no, that is not my case. my
That
lord.
is not your case. Now, if that being the position, that if you have consciously written, can you take a rebound by a change of
May I, my lord?
decision
May I, my
or
lord?
change of opinion later on, and that too?
No,
after
no,
a
it's
gap
not a
of 10
change of
years?
opinion, my lord.
You decided not to press.
My lord, may I submit, my lord? I
There may
decided
be a
not,
circumstances
the
which
circumstances,
which led you to sign on that. I can understand. After a realization, 10
no,
years.
it's not a
you have
decision, because after 10 years, the other side resile from that amicable settlement.
Now, if
Now-
that being, that being the position, then amicable settlement is like an agreement. It is like an agreement, legally enforceable in law. If that being the position, then why can't you take a recourse?
My lord, I was relying on the jet ply judgment. I had,
Please give it to us. I do not know whether it is here or not.
my lord, I am giving you, give my lord
Just
fresh.
1 minute. 1 minute. Let us see. So there was some communication gap in this regard. Anyhow, we are not going to say anything on this. So that judgment is not here.
My lord, may I?
Probably আরো আছে
Hello.
কাগজ? হ্যাঁ? কোনো judgments গুলো আছে রাখা? একটা আছে, দেখি। This is jet ply. Another copy is
May I
here.
hand over another copy, my lord?
Yes,
Well,
yes,
there's one more
jet ply,
Yes, my lord.
which
My lord takes page, paragraph 3, 4, 5, and 6, which sets out the
just 1 minute. Let us go through 3, 4.
facts, my lord. This
Yes.
was identical facts, my lord, almost, if I may say.
Yes. Yes. Which more paragraph?
My
3,
paragraph
4, 5, 6, 7. We have read.
8 are the facts, my lord, then
We have
paragraph
seen that.
17 and 18,
17.
where the argument is set forth.
Yes, 17 and 18.
And then, my lord, paragraphs 24, 25, and 26. Hand over the notes. Hand over to this one.
Yes.
And my lord, may I also rely on the judgment which is referred there and my lord approved is Rameshwar Sarkar versus State of West Bengal. I have AIN 1986 Calcutta, page 19. Well, this is on the issue that if the plaintiff has by mistake withdrawn,
Just 1 minute.
Paragraph 7, 6, 14 and 16.
Other, one of the petitioners wants. One of the.
Yeah, but let's say here. Coming with that, please go to court. দিয়ে দিলাম affidavit of service. I had submitted earlier on these lines only. I cannot possibly. My only case is
All these two judgments, they are pointed to an issue that the court is not powerless in recalling an order by which the suit was allowed to be withdrawn. In absence of any specific provision in the act itself, in the code itself, the inherent power is inheres into every court. For ends of justice, they can do it. But the question is, power is there. There is no difficulty. Such power is to be exercised under what circumstances? Is it such that the moment the party comes and says that sorry, I was mistaken, the court will recall immediately the order, withdrawing it, or something more should come? There must be some elements, some ingredients.
which is why I was trying to draw my lord's attention to the facts of both these cases. The two cases I have cited, in both these cases, the suit was withdrawn. In the Calcutta case, the suit was.
Facts, don't worry, but in both the cases, there are some very special facts.
This is this. In fact, my lord, Jetply, the case of Jetply, the facts squarely are similar to here.
No.
There also, my lord, on assurance is given.
No.
The suit was withdrawn and then the property was sold to somebody else.
I understand.
Here, my lord, what has happened is they give us propose a settlement.
Do you think that this is what the law says? It is an Article 141 or it is really under Article 142? Yes.
Even if, my lord, today, my lord, the situation is such, even the Calcutta judgment says if by a mistake,
Also on that.
If by, yes, my lord,
Also on
it
that.
says it is, both of them are on section 151, saying that the court is not powerless in such circumstances.
There is no
to recall.
quarrel, there is no quarrel to this proposition that the court's powers are still there. Even if the court is somehow, the court does not contain a specific provision in this regard.
My lord, my predicament is very simple. There is a decree. I filed an appeal challenging the decree. I get a judgment. Matter goes to Supreme Court. Matter is remanded back to this court, this honorable court, for rehearing of the appeal. At this juncture, BPCL, the opposite party, proposes a settlement, enters into a lease deed, pays rent for 10 years. Then suddenly, when a third party who is not related to the property, Metro Railway, wanted to acquire the property. RVNL, Railway Vikas Nigam Limited, was the contractor. The contractor writes to the Thika controller whether this is a Thika tenancy. The controller issues a notice. In May 2022, we come to learn that on 29th April 2022, BPCL, the opposite party, going against the lease, has is again trying to re-agitate the claim of Thika tenancy. The controller passes an order saying that there is a decree, the appeal was withdrawn, therefore the decree has revived, go. We challenge that order of the controller was set aside. But today the fact remains that the decree remains. I was, on the basis of the proposal, made to sign a fresh lease, the deed of lease for 10 years, even till last month. The lease rent has been paid. On one hand, BPCL is paying me the lease rent. On other hand, the Calcutta office goes before the Thika controller.
Now the Thika controller order is set aside. Now there is
A second proceeding has been started now, afresh.
the question is.
The question will remain that the
anything
decree remains.
is- Anything which happened subsequent to this, does it not give rise to a fresh cause of action?
Today that
The
fresh cause of
remedy-
action does not remain anymore. The
What?
decree remains. Thika controller will simply
That
follow the
was a
decree.
That was a conscious decision when you took.
The
by-
conscious decision was also on part of BPCL that it is not going to claim Thika tenancy.
This is what you say that we are not going to advise you.
No, I am
This-
not
at
even
least-
saying that.
At least you have a defense.
But my
I am
defense,
refraining myself because I know what.
I know I have a
what can
defense,
be
my
done.
lord, but my
but
defense
I am
is before the
refraining
Thika
myself from
controller
making
now.
any observation.
Now there is no civil
So,
court available.
Only thing is, a separate proceedings initiated subsequent to the disposal of the instant appeal. That's a fresh cause of action. If the remedy is available, obviously it should be available. Then you can take whatever the defense which is available to you, the conduct of the parties, everything. That is what is needed.
May I?
For that reason, why the court will keep this alive in that sense?
May I?
Why the court will make or say resurrect the deadwood?
May I, my
I-
lord? May I, my lord? My lord has asked me a question. May I try to answer it? My lord, today the civil forum on an issue of Thika tenancy is not available to me. Today, before the Thika controller, that decree will stare in my face. Because the appeal was withdrawn, the decree has revived. That is what the Thika controller earlier has held. There is no reason to believe that the Thika controller will not again hold that.
So that is on a probability presumption.
No, my lord, there is no presumption.
Thika tenant, the Thika controller may hold this. The Thika controller may not hold this.
My lord, that
There are
decree remains.
both the situations.
My lord,
are
the
there.
decree remains still. Today, I was misled.
Then what? Where is the case which is made out by you or misled?
My lord, I have stated that in my
That-
petition, my lord.
That suffice.
My lord, stated that in the petition.
After
Oh,
10
facts,
years
my
of
lord.
realization, now you realize that you were misled.
By their own action, not my action, my lord.
Nothing.
It is not a case where that
You were aware that the BS or whatever, I do not know. what is it,
PPCL, my lord, Bharat
PPCL
Petroleum.
has agreed that they will undergo with a fresh lease. They have undergone with a fresh lease. They are making a payments to you. You are realizing, as you said, even a last month rent has been paid to you. So all these things are still there. If they prevaricate their stand, that will be a matter where the forum where they will approach. You can go there, but this does not mean that we have to recall this order.
My lord, my submission is a prejudice will be caused to me if this is not recalled.
So structure What would be the resolution? Yes.
For my lord's convenience, I have prepared a list of date and short notes. My lord, those are my submissions, my lord. Short notes.
You are appearing for?
I am appealing for the appellant numbers 2 to 4.
So you have no grievance of withdrawal.
May I say one thing, my lord? When my lord heard this matter on the 24th of August, my lord made one observation that the act that is being taken by, that is being perpetrated by BPCL presently, my lord, that in itself is an illegality. We are all at item on that. My lord, the only submission is the apprehension of my learned friend that the decree will be staring at the face. It was observed by my lord that the effect of the decree is whittled down. So my clients have had always adopted that stand. My lord, the appellant number 1, my lord, without conferring with the other appellants, approached.
One clarification is required. Whatever the oral observation of the bench comes, that does not mean that is a law. So
No, my lord,
don't
that is
go by this is in the process of understanding the things and then the reactions and just to understand
my
true purport of the entire thing. It has got no relation with the ultimate decision.
No. I'm not on that matter. And the appellant number 1, my lord, filed the application without conferring with the other appellants. My clients have left it at your lordship's discretion, sole discretion.
And who is for the BPCL?
Notice was given, but nobody has appeared.
But Mr. Mitro sometimes appears for the BPCL, I think.
Well, in this matter, he appeared for the appellates earlier.
He appeared in one of the matter where I was an arguing counsel. against the BPCL, that's why.
Here probably he will, even if he had,
Before Justice P.S. Doctor. Yes, so they, despite notice, they are not appearing. Yes, let us first go through this. Tomorrow we are keeping it dictation will come in the open court. We'll have a discussion on this. Kalki, as for orders,
my lord, tomorrow, my lord will,
it's a dictation.
may excuse us,
No,
my
nothing,
junior
nobody,
will be there.
only thing is, we do not want to hear. If we need a clarification, if you're not there, then we will
No, no,
definitely.
my
If
junior
there
is
is no clarification,
there to
then
clarify, my lord. He is
nothing,
well
nothing
prepared.
is required. Yes.
My lord.
Can 6 and 7 you wanted to say. One is a
Can
condonation.
7 is the parent
Condonation
application,
and the
6 is
parent-
my lord, my limitation.
This is what I'm saying. Parent application and condonation application.
My-
Other applications are already disposed
They are
of.
all disposed of, because the appeal was
But they are
disposed of.
they are showing there's
Because
pending.
the appeal was disposed of, so the other appeal
Naturally,
applications cannot remain.
it is said that all connected applications are also dismissed in that order itself.
But sometimes, my lord, this recording doesn't happen at the server level.
What?
The recording of that all other applications are
It is there in the order.
it is there in the order, but it don't get reflected all the time. Particularly of the old orders, they don't get reflected. My lord.
Yes, call the next.
Lordship, Lordship, Ms. Sheboti Dotto is appearing on behalf of the petitioner, Your Lordship. She is not present. But Your Lordship, in the last occasion, the order was passed by Your Lordship on 8th of December. I have served the notice to the other side. Some certified,
We are appearing.
Lordship, some certified copies are needed for the final hearing. I applied for the certified copy through my client. Lordship, this is the letter I have served.
What certified copy is needed? I do not know. No, madam, have you seen the last order we have fixed? We say that nothing is required. We will hear out the appeal only on the ground because you say that there is an existence of an arbitration agreement. We need that agreement. That's all. Nothing more is required. The arbitration agreement. It was said that the suit is not maintainable. Preliminary decree cannot be passed because there is already an arbitration agreement between the parties. So parties has to, once they have chosen a forum, then they should go. On that ground, we just wanted to hear. That's the only ground they took. So no need to certified copy of anything. Only agreement show us and the plaint, we will see to it. What is the nature? That's all. And application of certain provisions of the Arbitration and Conciliation Act.
Lordship, I do
That's
not
the
have
only
the
thing.
document. Lordship, kindly pray
It's
for
there
2
in
weeks of
can.
time, Lordship.
It's there in can two.
Where is who is for the where is Mr. Pradeep Kumar? No, he said, now I remember, I didn't know this. He said, I have taken a change yesterday. I could not go through the brief. Please give me a time. Both of us, in their presence, where he gave a consent that this matter should be fixed here today. Madam, sorry, you have been, I'm not using that word.
No, well, I will.
At least both of us are very much averse to an adjournment. And that too on this score, when the court is taken for a ride, And after the promise and assurance is given by a counsel that I will argue the matter on that day, and then sending a junior to secure an adjournment, we will not appreciate it, and nor we are going to accept it. And this is the reason why the courts in the countries are grappling with the huge pendency of cases. It's not the fault of the bench or a court itself. It's a collective duty of the bar as well. We will not. Now, I didn't know because you remember that I was not, then why you accepted the brief? Then he said, okay, fix it on that, I will argue. And tell your senior that both of us was there for a pretty long time. We know all the tidbits.
No, Lordship, she is suffering from fever. She is
No,
not present, Your Lordship.
No. Okay. Who's?
Actually, brief.
No, Mr. Pradeep Kumar appeared.
I understand. I was told.
He said that I have received the no objection yesterday.
And your lordships were
Because my principle in the profession was that I never used to appear in a change brief. I never. And I used to discourage this. So anyhow, we granted him a time. Matter was fixed today. You'll have to. Where is Mr. Pradeep? He was supposed to. He was there. He's supposed to. No, we will dismiss it. If he does not, then we'll dismiss. Can't.
Somebody are not present.
Sorry, we can't. We can't.
Lordship, the brief is allotted on Sunday, Your Lordship. Lordship, I only pray for 2 weeks of time.
This is what is happening. The matter was pending for a pretty long time in the brief. Suddenly, on 3 occasions, the adjournment was sought by the erstwhile advocate. When we were rigid that we will not grant adjournment, sudden change took place. The new lawyer, he comes and says, I have accepted a change yesterday night. Please grant me a time. This is how the ploy is to get an adjournment. Again, today, if we grant time, we are sure and confident that if we fix the matter tomorrow, another gentleman tomorrow will come that I have accepted a change. We are quite confident in this regard. When a member of the bar is assured that he will argue the matter on that day, it is not expected that he is not here. I can appreciate that somebody has been engaged, but at least he should be here. And expose the junior. Absolutely a calculated attempt to get the adjournment.
Kindly take it up at 2 p.m. My lord.
We will dismiss it.
It is in any event, it is in my exclusive submission, not because I am appearing on behalf of the respondents. It is in any event liable to be dismissed for this reason. The suit is a suit for partition. The plaintiff respondent before your lordship is the owner of 75% of the property, admittedly, and my lord, the appellants, the defendants were the owner of, my lord, 25%. They jointly purchased the property by a common deed of conveyance. My lord, thereafter, my lord, there was an agreement. So that deed of conveyance naturally did not have any arbitration clause, could not have. Now, thereafter, they had, my lord, entered into a subsequent agreement to jointly develop the property. The agreement in writings provides that the agreement will come effect only when a building is constructed. That agreement contained an arbitration clause. So today, the right I am trying to enforce in this suit is my right as co-owner, not my lot for development. So the dispute is not, cannot be covered by arbitration, number one. Number two, as per the Arbitration Act, my lord, the arbitration and
I have participated section 8. I am conscious. I did not. That's why I say in a very, broader manner that only the agreement and the application or interpretation of certain statutory provision. I am conscious of section 8.
Lordships deal with those.
And they realize that what they have to face. And this is how they wanted to avoid it.
The only difficulty is, my lord, preliminary decree. There
And
are
it has further steps for final decrees.
further steps, my lord. They did not press this application. Then, my lord, they have taken exception, or my lord, they have filed an application to the report filed by the commission.
So that is the course that is there in the suit. They will take care of that.
They have accepted the preliminary decree by doing that.
Madam, sorry, we can't.
Only prefer not today, your
No,
lordship.
madam, this not today is because you say today, the tomorrow never comes. It's a quite old days which says that the tomorrow never comes. Tomorrow when we fix the matter, you will say today. Only for not today. Again, day after tomorrow, you will treat that day as today. So tomorrow will never come. Every time it's today. Sorry, madam, we can't. And we'll record the conduct of this advocate as well. Nowadays, the minutes concept has gone because the minutes are not prepared. Previously, these minutes used to be prepared by the department. When this matter was taken up?
8 December, your lordship.
8
December.
So we will, and at what time we will play the recording of what has happened on that day. Where is Mr. Kumar? Dismiss, madam.
Whatever lordship deemed fit.
Kindly.
No, I understand the entire, the modalities are well known to me. It's not that it is not.
I understand, my lord. On 1st of December, time was taken by one advocate. Then on 8th of December, Mr. Kumar appeared and he took time.
He gave an assurance when we put
I-
this
I was
question.
told.
When he gave an assurance, I will prepare myself. I will argue. Don't worry. I have one of the best case. So on that score, we said, take time, prepare yourself, come and argue. And today you see he's out of picture. Somebody's name is there, and the junior who does not know has been sent.
Kindly record it and keep it for two. Not for any other reason, my lord, to
No, that's why I was there. It's not that I have not
no, taken it.
I have not worked with him or I have not worked appeared against him. I know all this. What is the problem with that? That the person has to migrate from there to here.
Knows all the
He
tricks.
knows all this because he was a part of two tracks. You have also appeared in the I think this is not correct. You are literally spoiling your career. Be an arguing counsel. Do not come and do all these adjournments. You email seeking for an that will not give a good impression.
I pray for apology, your lordship, but I am appearing as per the instruction.
You only for the purpose of an exam. This is what is the problem.
The whole difficulty is he possibly did not know what transpired on 8th and what is
Oh,
happening.
lordship.
That's why I say
That's yes.
that is what is happening. Done. You just not know anything. It's a sorted state of affairs that the council presenting the appellate at the last occasion assured the court that he would argue the matter on the next day. But yet, when the matter is taken up today, the said council neither appears. The said council has not appeared and sent the junior to an adjournment in the pretext of engaging a senior who is in this. On 18th December 2023, when the matter was last 8th December 2023, when the matter was listed last week, the council for the appellant appears that he has that he has taken a cheap, that his client has taken a cheap and have entrusted the briefs to him on 7th December, and therefore a reasonable time should be given to prepare for us. It is really unfortunate that such a device is innovated at the bar to secure the and simultaneously simultaneously making a communication to the trial court that the matter is pending before the High Court. Such modalities have negative impact on the disposal of the cases in a time-bound manner, and resultantly mounting the heap of the pending cases, heap of the pendency in the docket of the courts. Though we are not inclined to grant any adjournment today, but we are quite oblivion of the we are not oblivion of the fact, quite oblivion of the fact that the dismissal of the appeal shall have a larger impact on the justice to be imparted to the litigant, who cannot be said to have committed any fraud in engaging the counsel. for ends of justice, we adjourn the matter today. And with the direction that this matter would be listed day after tomorrow under the same heading to be taken up as a first matter next. 2 days says indisposed fever, so they have to take arrangement for another advocate to be used. So we have given 2 days time.
Pay for apology, your lordship.
We have not recorded the name of the advocate in the order, having a very cascading effect on his career. Good. Oh.
My client has already vacated the suit.
The other side. The other side.
No other side, ma'am.
They vacated, so you do not want to proceed.
Do not want to proceed. No.
Have an instruction.
No, no written instruction.
You owe the responsibility.
Yes.
This is against a eviction decree.
Eviction degree.
There is a junior.
She has not come today.
Are you also a joint secretary of the Wakalatnama? Then subsequently. Very the hearing for the applicant submits one instruction received from the client that the client is not interested in proceeding with the instant appeals as he has already vacated the suit himself and delivered the vacant position unto and in favor of the respondent landlord. Landlord will respond. The instant appeal arises from a judgment passed by the trial court directing the recovery of possession and or eviction of the appellant. And the moment the appellant has vacated and handed over the position, there is no point in keeping the appeal pending. Since the appellant have decided not to proceed with the instant appeal, both the appeals are dismissed for non-prosecution. Lower court record has come, no? Lower court record has come or not?
No.
Is order 41 stage?
Yes, what?
Let's go that. So.
My 7, my lord, your lordship heard the matter substantially with justice.
Not substantially.
Yes, my lord. Both the parties filed, my lord, kindly. This is that matter, my lord.
But this was not kept as parted or a judgment.
Maybe.
কোনটা? ওটা আমাকে জাস্ট দেখিয়ে দিও। দুটো অ্যাকচুয়ালি ক্যান 6 ক্যান 7
এইগুলো বার করো।
অ্যাপ্লিকেশনটা আলাদা করে বার করে আর এই জাজমেন্ট যেটা দিয়েছি মোটামুটি পুরো ফাইলটা দরকার নেই, বাট তাও পুরো ফাইল কিন্তু ওটা তুমি ওটা রাখো, ওটা ডিকটেট করো। ওর সঙ্গে কথা বলে নিই। Now you have to argue afresh because
Very well. What happened, my lord? Kindly see two documents which has been filed both the parties before your lordship.
this Avdesh is
Or this is the plaintiff.
plaintiff.
Plaintiff. It is lordship के दौरान type करा.
So he has agreed, and
That-
you have also
Yes, yes.
agreed
But kindly see,
900 and 100.
yes, yes.
No difficulty.
Well, what happened, my lord? A suit for partition has been filed.
So what to do? The injunction was there, so we have to lift the injunction.
Everything will go because, my lord,
But they have to go and approach the court. in
that's
the
the
trial court, not-
that's the observation from your lordship, my lord.
They have to go and approach the trial court for withdrawal of this, and they have agreed. This is a suit for partition.
Yes,
What is the nature of the injunction?
I'm telling you, lordship. Plaintiff filed a suit for partition. And I am the developer, my lord, who, my lord, from the other legal heirs, my lord, has already executed deed. In that deed, my lord, the plaintiff's son is a party. Now, my plaintiff says that my wife, my wife has a share of the property, and my son entered the development agreement without giving consent, without consent of me. Therefore,
That is the property of the wife's side.
wife side. And now, my lord, ultimately we agreed that very well, the son is already getting the property, and they said some portion if you increase, we agreed that.
So there's
Therefore, my
nothing-
there will no injunction, and the suit they will withdraw in view of this. बाकी भी होना चाहिए दुनिया में you will find page 16 of the deed which have
Oh. It was a suit simpliciter for partition.
partition. Now, my lord, on the last, if you actually only use one word, last time you actually said that in view of this, they will go before the court will, and we
Oh,
agree.
they will go. They are here. They will.
And
they will
injunction,
not-
and
kindly record 900 covered area that was written.
That is.
now what we have written.
Covered area and 100 covered area.
Now, what we have given, that will be. এটি তো লেখা আছে ভালো নতুন করে কেন বলছিস
He has not covered.
এই তো কভার লেখা আছে এটা সব তো আছে
No. Lord, this is not the Lord. He has written proportionate share, staircase, lift, etc.
হ্যাঁ পুরোটা পড়ো পুরোটা
But on last occasion, my Lord,
Please read that. When he says you read, then you read.
represented by my mother, Raju Kundu, are agreed to provide 900 square feet flat, including the proportionate staircase.
পড়ো
Or has to be. Staircase has to be, yes.
Staircase and lift area and
Hmm.
100 square feet covered area in favor of Agras, that is the plaintiff. That was not the written, it was agreed.
No,
by my
no.
client.
On that day, we have given this.
No,
Kindly
but
see, my lord.
It is on record, my Lord's record.
No, it is there.
Yes.
No. He says 900 square feet.
Only the covered area flat.
900 square feet what?
He has written 900 square feet flat, including the proportionate staircase and lift area. Then, and 100 square feet covered area in favor of the plaintiff.
Please, everyone,
That means not the 900 square feet including the staircase and the lift. And 100 square feet that is shop area, that is the covered area, according to him. But
everyone,
it was agreed.
no, not that.
900 square feet not the covered area, residential purpose, 100 square feet covered area for commercial purpose. And exactly that was written,
But
it
this
was
has been
written by
handed
your
over
client.
to them in presence of his client, and kindly see everyone who is getting 725 on your lordship's.
725 of what?
May I kindly see
Covered,
page
covered
16.
or without covered?
Covered.
Kindly see.
Covered.
700?
Kindly see.
Character 9 they have
Done,
stated.
देखिए दीजिए. May I kindly see the deed page 16.
16. Yes.
Yes. 6 number of self-contained flats having covered area 725.
Covered area.
Yes, that he will get. He will get covered area.
No, he was saying that he wanted more.
That's why my 100 square feet. My kindly see, now he is getting 900.
So
Instead
that is
of
a covered area.
covered area.
No difficulty.
But that is why
Who is saying so?
he has written the.
Sir, when the court is recording that,
My client is here, 900 covered area.
কি বলেছে?
900
This-
square feet এটা covered area তো.
This appeal arises from an order dated 30th June 2023, passed by the Learned Civil Judge Senior Division Second Court Barasa, North 24 Parganas in title suit 536 of 2019. Whereby and whereunder an application under order 39 rule 4 of the Code of Procedure filed by the, you are the defendant number 9 there,
Defend number 9.
filed by the appellant hearing was rejected on contest. Full stop. The plaintiff respondent filed a suit for partition and separation of shares, claiming his undivided right, title and interests which he received on the death of his wife as the heirs under section 15 of the Hindu Succession Act. All the co-sharers, including all other co-sharers, including the son of the plaintiff respondent, entered into an agreement for development of the said joint property, which which contained the specific allocation. Stop. Since the plaintiff appellant was not a contracting party, he defied the said development agreement and instituted a suit for separation of his share from the other co-sharers. The trial court passed an injunction directing the status quo to be maintained with respect to nature, character, and construction at the suit premises. And on the notices being served, the appellant filed the aforesaid application for vacation, variation, and setting aside the said ex parte ad interim order of injunction. In course of the hearing of the instant appeal, the proposal and counter proposals were made by the plaintiff as well as the said developer. And in course of, and it was agreed that the appellant along with his son shall be allotted 900 square feet covered area of allotted a flat measuring 900 square feet covered area along with his son and shall further be provided the 100 square feet covered area for the purpose of shop. The plaintiff appellant has written a letter to his advocate on record of this court on 21st August 2023, which is taken on record. It's signifying his intention as indicated above. The appellant have agreed to provide and allot such portion, that is 900 covered area, the flat measuring containing 900 square feet covered area, and a shop measuring 100 square feet covered area at the proposed building. In view of the above, the plaintiff respondent submits that there is no point in keeping the order of injunction operative, and therefore, on such basis, the appeal may be disposed of. So, in view of the above, the order of injunction passed by the trial court is hereby set aside. Stop. Both the parties are directed to approach the trial court for seeking dismissal or disposal of the suit on the basis of a compromise and or agreement entered into in course of the instant appeal, which shall not exceed beyond 2 weeks after the reopening of the court following the Christmas break.
And may I just take back the document filed by
Let the what?
no one
Let the let the original letter issued by the plaintiff respondent to his advocate, Mr. Amit Karmakar, and filed in court today, be kept with the record in a sealed envelope.
and the document filed by my client in favor of the advocate on record.
What?
Because my client also agreed, my lord, on writing.
Where is that letter? Oh, sorry. Line to the the appellant has also issued a letter to his advocate on record, signifying his intention to agree to the proposal of the plaintiff respondent. So let such letter be also kept on record. Now let such letter last stage envelope monde, let both the letters, original letters, be kept in a sealed envelope.
Let
in future, if they want to say sealed envelope in mudde can be. Let us see any matter. Yes, call any matter. Other matter, let us see. What is the next matter?
I'm the appealant. The matter was heard by all once. So I just said, but I have no case. I'm for the
You have no case.
Yes.
No.
I said, but that day I said, what happened? I said, what? I'm the appealant defendant number 2. I'm the subsequent purchaser. What happened? The plaintiff filed a suit for
Specific performance of an agreement.
for declaration of title and injunction. And that was dismissed. And subsequently in the appeal court remanded back it before for including the prayer for recovery of position. In order of remand, I have challenged. You lastly said, Mr. Rai, make out a case when you have the adverse position. Article 65 of the limited, I can't. My lord, that day I said, no, I do not have any case.
Because your lordship knows me. Your lordship, Mr. Raj, show me. So what do you want? Let it go and file.
Yes, yes, that was hard. I suppose already I have instructed my client, they file the written statement also.
So, so we'll dispose of.
Yes, yes. This was, there's no basically not to proceed with my lord.
That is what I was
That will
thinking.
better, my lord. Not
That
to
is
proceed.
because if we make an observation.
Yes, then that will go to the. I said what happened that day. You argued.
Have you taken an instruction?
No, I have taken instruction. I just
No difficult.
no problem. I call him written statement. I say this one.
Yes, the council.
But this is Article
But
65
the
and
appellant
64.
submits on
You
instruction
don't understand the.
that his client has showed his intention not to proceed with the instant appeal. So he further submits that the instant appeal was filed sealing the judgment and sealing the order of remand passed by the trial court. He further submits that his client has already submitted the written statement in the trial court, which is proceeding with the matter after remand, and therefore there is no point in keeping the instant appeal alive. So in view of the above fact, including that the client that the appellant does not intend to proceed with the instant appeal, the appeal is dismissed for non-prosecution.
But the judgment Justice Bhattacharya is still in the middle of it. You also see that. Yes.
My lord, I am for the appellant plaintiff. My lord, in terms of the order dated 5th of December, my lord, I have added all the respondents, all the defendants as the party respondent, my lord, from 9 to 95.
Where is the plaint?
Correct. Can we come to Can, my lord? Page 9.
So you are really assailing, not assailing, but you are assailing that Bontonnama.
Yes. My lord, I am appearing on behalf of the plaintiffs, my lord.
Oh, I know you are assailing the Bontonnama.
Yes,
You are
yes.
saying that the Bontonnama is a void,
Yes.
illegal, ineffective.
Yes.
And then you wanted a declaration of your share of four annas.
Yes. My lord, as the defendants, some of the defendants, my lord, tried to construct illegal construction, my lord. My lord, the plaintiff filed one, order 39, rule 1 along
No,
with.
no, that I know, but that you wanted an injunction. Who are the
Yes.
defendants who are trying?
My lord, kindly come to.
Where is the application for
Yes.
injunction?
This is the application for injunction on 22nd of March 2022. And my lord, this is
What is
the
the nature of injunction you asked?
partition suit, my lord.
Nature of injunction you have asked.
My lord.
Where is that? A partition suit we understand.
Yes.
We just wanted to look
Yes.
at the nature of injunction. Where is the injunction application?
Injunction
You have annexed the plaint, but you
Yes,
have not
sir.
annexed the injunction application.
Yes, my lord. This is the injunction application.
के लिए बहुत difficult वाला situation.
My lord, paragraph 11.
এক হইতে 3 নম্বর বিবাদীগণ ও 6 নম্বর 9 নম্বর 10 নম্বর and 11 নম্বর বিবাদীগণে যাহাতে নালিশি সম্পত্তি
এবং 25 না।
and 25 I do not find 25
My lord,
এক হইতে 3 নম্বর বিবাদীগণেও
হুম।
ও 6 9 10 11 নম্বরে বিবাদীগণের যাহাতে নালিশি সম্পত্তিতে বাদীগণের
paragraph
শান্তিপূর্ণ
12,
ভোগ
my lord.
দখলে কোন রকম বাধা সৃষ্টি না করিতে পারেন and বেদখল করিতে না পারেন হস্তান্তর করিতে না পারেন নালিশি সম্পত্তির নেচার বা ক্যারেক্টার পরিবর্তন করিতে না পারেন এবং নালিশি সম্পত্তির কোন প্রকারে অবৈধ that you say the construction
Yes.
করিতে না পারে জন্য বাদীগণের অনুকূলে 1 হইতে 3 নম্বর এবং 6 9 10 11 নম্বর বিরুদ্ধে অস্থায়ী
My lord,
I didn't read.
paragraph 12, my lord, paragraph 12.
I am asking the injunction which you
25.
have prayed for.
Yes,
You have prayed for against these defendants only. You have not prayed for any other defendants.
my lord, kindly come to
And
next.
the court
The
has said
injunction-
that till date, the 3, 6, 9, 10, and 11.
My lord, injunction petition dated 22nd of March, my lord.
So you have given me this.
My lord, that is earlier, my lord.
I do not know
At the time
what
of-
application has been. This is the application filed on 22nd of March.
No, my lord, this is, my lord, I have supplied this copy, my lord.
This
2nd of-
copy.
yes, my lord, 2nd of March.
And Pochis.
And Mochis, my
Yes. And who they have not appeared.
lord. They have not appeared. My lord, I served copy, my lord, as per my lord's instruction.
Whether the summons were served.
My lord, I have supplied my lord affidavit of service earlier.
No, summons in the trial court was served.
They appeared, my lord, all along, my lord. I have
No,
stated.
not. They say that till date, the defendant number 25, 3, 6, 9, 10, and 11 did not appear. So that is what I'm asking.
Yes.
The court has said that these are the defendants against whom you asked for an injunction. They have not appeared.
Another, my lord.
Whether the summons, because I find that the 19, 20, and 21,
Yes.
they entered
They
appearance and
appeared.
find written statement after service of summons.
Yes.
Whether the summons were served on them, these defendants. I'm just asking this question in the suit.
My lord, then, my lord, I shall take.
You are not ready. You ought to have been when you have seen the order.
My lord, I have stated in my.
If the service was there, then it's all right.
My lord, in my memo of appeal, page 4. Paragraph 8, my lord.
Have you served these defendants?
Yes.
Have you pleaded
One
them?
to- one
They
to
were
8.
there in the original memorandum. These
Yes, ma'am.
defendants?
Yes, my lord. 1 to 8.
No. What about 25?
Yes, my lord.
He was there
8,
in original.
8, my lord. My lord,
Was defendant number.
Sheikh Basid is the defendant number 25.
Yes. Was he there in the original?
Yes. Page 625 serial number.
So if they come and appear, then they opportunity to.
Serial number 25 in my plaint, my lord. Serial number 25 in my plaint.
Yes.
Serial number 25 in my plaint.
Subsequently added by a.
No.
If they were there.
They were there.
But you'll have to say so. That they summons were served upon them. Will have received in the bit of 14, 15. So my view is that every co-sharer has a right to make construction, provided he will not claim any equity at the time of final decree. So at this stage,
My lord, the appellant plaintiff, my lord, the grandfather of the appellant plaintiff names was recorded in the RS record of right, my lord.
that is not a document of title.
Yes.
There was a Bontannama which was executed by the parties. Bontannama is like a compromise. The parties have entered in.
But without any knowledge of the predecessor of the plaintiff, my lord.
That is what
That
you
is
have,
the question.
that is what you have assailed.
Yes.
So one has to understand in this way. You are not your predecessor was not a signatory to that Bontannama.
Yes.
And the RS recorder, right, is you have said for erroneous recording. Your name, your predecessor's name is not there.
Yes.
So
Will kindly take it up on Thursday, my lord. I shall take instruction.
you'll have to show, otherwise we can't give you this.
Whether someone has been served on.
Yes. Even otherwise, we will permit the construction, but they will not claim, we will not say anything, but they will not claim any equity at the time of penalty. Ultimately, if you succeed in establishing, then your preliminary degree will say that what you have claimed for Charana onshore.
Yes.
So that preliminary degree will say, and then final degree, that allotment would come on the basis of equitable principles. They will not claim.
Then, my lord, kindly take it up on Monday, my lord. I shall take instruction and documents from the client.
Not this week.
আরো দুটো আছে।
My lord, item number 12, I appear for the petitioners, the appellant lordship. If your lordship recalls, I had moved this appeal last week, your lordship. The appellant is the plaintiff in a suit for specific performance of contract. My application under Order 39, Rule 1-2 has been rejected upon a contested hearing on the ground that the agreement between the plaintiff and the respondent was not stamped, and because it is not stamped, it cannot be taken into evidence, and it has to be impounded, which can only happen when the trial begins. Now, certain queries fell from my lord on that day, and lordship, I'm very grateful for that, lordship. I have looked up, I have checked up, and have come back. Section 33 of the Stamp Act states that it has to be, it cannot, if it has to be acted upon, or if it has to be taken into evidence. Then, lordship, and your lordship had already indicated the main difference between section 33 and 35 is the word that acted upon. Now, lordship, on that score, may I just submit this? Section 42 states of the Indian Stamp Act states that when it cannot be taken into evidence, but it can be acted upon if it is impounded and penalty is paid as per section 35.
No difficulty. Section 33 is very clear.
Section 33, section 35.
If it is impounded, then it can be definitely acted upon. No
Lordship.
problem. There is no quarrel.
Yes, lordship.
There is no hesitation nor any confusion in our mind.
Lordship. Now, lordship, in the impugned order, if I may now come to the impugned order, the learned trial judge, and very humbly I submit, lordship, has erred in holding that it cannot be taken into evidence unless it goes into trial. Now, there is a judgment of
No, trial I can understand. That is a different.
at the threshold, lordship, if it is being rejected, it will only lead to multiplicity of proceeding, and also
No.
if it is sold off,
If the
lordship.
court cannot act, your right emanates from an agreement for sale.
Agreement for sale, lordship.
So the court, while passing an injunction,
Lordship.
really acting upon that document.
Yes, cannot.
Take it that he cannot. If he cannot, then how and in what manner the court will pass an injunction?
Lordship, and that is why I submit very humbly, lordship, it could have been sent by the learned trial judge for the document
Impounding.
to be impounding.
No difficulty, madam. You are absolutely correct. The court should at least keep this application pending.
Yes, lordship.
And then send the document for impounding.
Impounding. That is.
After the impounding is done, and in terms of section 42, the payment and the penalty is also deposited by you.
It can be then acted upon, my lord.
Difficult. No difficulty.
And
Who
even,
says no? That's the proposition of law.
and Lordship, another query that fell from my lord was that how can an appellate court act as a trial court? Lordship,
No, he has all the powers of the trial court.
yes, Lordship, section 107 and
107.
107,
of
and
the Code
also
of-
Lordship, Order 41, Rule 33 also.
Oh,
No, the powers of the appellate court,
oh,
Lordship.
33 is not akin to a powers of the original court.
Or not original court, Lordship,
It
but
says that the
section
court, if we
107
find
is,
that certain reliefs can be granted
Lordship,
to the parties, the appellate court can
can.
pass such an order, even if there is no challenge in this regard. There is
Yes,
no
Lordship.
difficulty.
Lordship, that
It is a
is
different. Akin to original is 107.
107, Lordship. So, Lordship, that is my only prayer. Let this be remanded back. Let the trial court first send it. My humble submission, Lordship.
You serve them.
This is odd. No caveat has been filed, Lordship. Order
In
41,
their presence, it has to go. Because we are setting aside the order.
Lordship.
So he has a right to be heard.
If your Lordship so directs,
Absence, can we allow the appeal? Again, he will come that we were not given a notice. How the court set aside the order.
if your Lordship so directs, because there was no caveat, Lordship, we did not serve.
We should have simply done. So there was presence. Even after admission, it would remain with us. So let us happen. The only point involved in the instant appeal is whether the trial court was justified in rejecting an application for temporary injunction, holding that the agreement for sale containing an insufficient stamp cannot be acted upon, and the impounding can only be done at the time of trial. To stop. In view of the above, we admit the appeal, direct the appellant to serve the copy of the injunction application upon the respondents by speed post, as well as the learned advocate representing them in the trial court. They are represented there.
Yes, Lordship.
The trial court by hand, and shall file the affidavit of service on the returnable date. The application is made returnable on 20th December.
Lordship. Lordship, and interim protection in the meanwhile until the 20th, Lordship.
What are you talking? Then we are acting upon.
Lordship. I'm deeply obliged, my lord.
Maybe your lordship. The plaintiff, the appellant before your lordship, is judgment of reversal. I am the landlord. I file a suit for eviction on the ground of first position. As
On
a
the ground of khas position. That is not a ground.
degree for first position, and also a defaulter clause,
Decree for recovery of khas position.
and also
Say that.
reasonable requirement and defaulter rebuilding.
So
others.
decree for khas position is a relief. Ground is
Recovery of possession as well as
is a relief. Ground is reasonable requirement and
defaulter
default, and
means profit.
that is not a ground. That's the consequential relief.
The trial
Two
court,
grounds.
the
Yes.
trial court decreed the suit,
Both on both the grounds.
both the grounds.
Both the grounds, default and reasonable requirement, or only on the ground of reasonable requirement.
No, both the grounds.
7-2 or 17-2, not 56 Act or 97 Act.
97 Act.
So 7-2 was complied.
But that was not make an application by the trial court before the defendant.
Did you apply under 7-3?
No,
Did not.
my lord, the appeal court remanded the matter on the ground one application filed by the defendant, order 16 rule 14 of the Code of Civil Procedure, that the application was not decided. As
Better
a result,
particulars.
remand the same.
614 is a better particulars or a
Order
expunction?
16 rule 14, my lord.
Order 16, Ocha. Recall.
16.
Recall of the witness.
Court may of his own accord summon as witness stranger to suit.
Yes.
But the
What
trial
witness?
court,
Sorry.
upon contested hearing,
Reject.
no,
Disposed of that.
contested hearing and kept away still
The suit.
disposal of the suit.
And
And
ultimately.
while the trial court disposed of the decreed the suit, come to a conclusion that application is not maintainable, considered and rejected.
Correct.
But the appellate court, first appellate court, come to a conclusion that the trial court has not decided the same. As a result, I compelled to direct the trial court to conclude that portion. Accordingly, the appeal is remanded. My point is, while the application was disposed of,
Another query.
yes, ma'am.
In the memorandum of appeal filed before the first appellate court, did they challenge that portion of that order?
Yes. Only that portion is challenged.
No, that was challenged in the ground was taken.
Yes, they have taken the ground that application is pending, not disposed of. The trial court
They
decreed.
they simply say pending. They did
Pending.
not say wrongly.
No. Pending.
You have the copy,
I have the copy of the order.
memorandum.
Memorandum, no. I have no memorandum.
One question filed from your lordship. Whether the shoot is at all maintainable at the instance of the plaintiff who is claiming himself to be the landlord, although the rent is being
That
realized.
question does not arise at all because it's a remand order. Supreme Court says only that portion be re-edited, that portion be concluded, no other further portion. It is a Supreme Court judgment. Only remand. Why remand? The Supreme Court says, as and when the appellate court remand the matter very cautiously. No further point, no further fact should be re-edited. Only the point, while the first appellate court remand the matter. Under Order 43, Rule 1U says that only that point be decided. No other take your seat.
Memorandum is
বাবা বসবো না বাবা সেদিনকে তোমরা মিটিগেট করেছো আমাকে কি হয়েছে দেখুন
memorandum of appeal.
My lord, my junior friend correctly says that in my stay application I have annexed the memo of appeal. Memo of appeal. Kindly see page 62. Annexed there P4.
What ground has been taken? Then why you scolded him?
Yes.
Why you were scolding your junior?
No. That day I request them. They don't do.
No, just now he was pointing.
No. I'm going to take your seat. Then I. That day misguided. That is why I have rebuked by your lordship. That is why I have. He is my very good friend. Yes, they have taken the ground number 14.
What?
But for that, the learned trial court committed a factious pose by observing that the defendant appellant failed to prove the writing of rent receipt signature Rekha Sarkar it is due execution, no step was taken by the defendant appellant to call Rekha Sarkar as a witness, but ought to have considered that said Rekha Sarkar, being sister of plaintiff respondent, may not be disposed to the court either on his requested by summoning her to court, and presumably she will give evidence in favor of the plaintiff respondent, and in that situation only provision laid down under 16 Rule 14 and read with 151 of the Code of Civil Procedure, read with 165 of the Indian Evidence Act was open to him, under which he filed an application before the trial court to said Rekha Sarkar being the court witness, so that the defendant appellant can cross her on happening denial of signature and duty execution of the rent.
Has he said anything about that this finding of the trial court
Regarding
rejecting
disposal?
an application is absolutely wrong? I am just asking this question.
No, they have not taken. Only point pending. The order was not challenged.
In the memo, they have said that pending that application, the suit has been disposed of.
Yes. They have taken the only surmise and conjecture, the first appellate court come to a conclusion that undecided. How is it? Undecided.
Where is the ground? We wanted to know. The reason is obvious. Why we are asking you this question is obvious. Obvious means section 105 of the Code of Civil Procedure.
My lord, while the trial court deal elaborately that this order 16 rule 14 application is not maintainable.
Yes.
165 of the Evidence Act says judges power to put question or other production. Here court thinks the Rekha Sarkar is not necessary because the application which was filed by the defendant, that was elaborately discussed and considered and rejected. Only at the time of passing the order, the trial court one line added, the order, the application be kept abeyance till disposal of the suit. But while disposal of the suit, the last paragraph, the learned trial court come to a conclusion that yes, I have read, I have discussed, accordingly the application is maintainable, reject. But the first appellate court come to a conclusion undecided. How is it? I am asking myself. Undecided. As a result, I compelled to remand the matter. The record says, the order says it was elaborately discussed and come to a decision. Order 51 dated 21st September 2021. That day I have submitted before your lordship. May I permitted to read?
Kept in abeyance.
Abeyance till disposal of the
True. We understood.
yes. But the application was discussed and considered. Both parties filed their written argument.
But ultimate decision not taken.
Kept abeyance.
It was discussed, it
Yes.
was considered, but the ultimate decision was not taken by the
No,
court.
this order says
That this is what is there, we will decide at the time of the final decree.
kept abeyance.
What does it mean? Kept in abeyance means
Till
means no final decision is taken on that application.
Yes.
And this application would be reheard or will be heard at the time of final hearing.
But that is not a question here, my lord. The trial court come to a conclusion till disposal of the suit kept abeyance. Means, my lord, while the trial court decreed the suit, passed an order. I'm coming to
Oh, I know it. So according to you, it
Yes.
was kept in abeyance, and at the time of passing a decree, the trial court considered that application and rejected it.
Yes.
It is your contention.
Yes.
why you say the court consider on in order number 31, consider, but there was no decision in order 30 order number 31 by the court.
51.
51 by the court. No decision was taken.
But the court come to a conclusion.
Sorry,
It
where
will
is
be,
the conclusion?
it will be decided. It will be kept abeyance and final decision of the trial.
What does it
should-
mean? What does it mean? That
It will be reopened again. My answer is, I am asking myself, my answer is no.
no.
Yes, because I am
Oh.
reading this order.
No, it's
But
not
that order
necessary.
was not challenged.
No.
The order which was passed on 21st September 2001, as and when the trial court came to a conclusion, kept abeyance, that order was not challenged.
Sorry. What is the meaning of the word kept in abeyance? Means the trial court did not finally decided the issue, that application. There was no decision which was taken on the said application. This is the meaning of the word kept in abeyance, that the decision would be taken when the suit is heard, finally. Kept
Yes.
in. Now, while passing the decree, the court has taken into consideration and then rejected that application. So, that order will not have any bearing. Ultimate decision taken in the judgment by the trial court is the bearing one. This order, who will challenge? If you come before us, before any of us, in revision, challenging the order, we would dismiss with cause.
No.
If this interpretation is given.
Suppose someone dissatisfied with the order.
How? First thing is
Regarding kept abeyance.
If you can say that he should not have kept in abeyance, that is the one issue.
Yes.
If you say kept in abeyance means he has already decided everything, cost.
No, I am not saying so, my lord. Kept abeyance means kept abeyance till disposal of the suit. As in when the trial court, after considering the evidence, all the parties, and came to a conclusion that the application which was filed by the Hassan Siraj is considered and rejected.
So it is rejected. Why anybody will challenge this order?
No one challenged the same. No one challenged the same.
It's not challenge. Why he will challenge?
So my contention is that only remand that point. The first appellate court wrongly come to a conclusion that it was not decided on merit. My contention is no. It is wrongly the first appellate court come to a conclusion it was not decided. My contention before your lordship, the Supreme Court says in 2004, volume 4, Supreme Court cases, page 26, in the case of Narayan versus Kumaran and others, here, my lord, the court came to a conclusion as and when the appellate court remand the matter, the only that point be agitate before the court. But my lord, see page 17, paragraph 17. No other point cannot be re-agitated. Your lordship knows, my lord. This is my submission.
Thank you.
No other point cannot be, should not be re-agitated. Only that point.
If my lord may kindly comes to the trial court's order at page 50. Page 50, may I please be
Internal page.
in page 49, last page, last line. Internal page, it will be 8,
Of the trial court.
trial court's order.
Yes.
It is an admitted position that Santosh Kumar Saha was the original owner and landlord of the suit premises, and the defendant was inducted.
Oh, last line.
Last line of page internal page 8.
Page 8 of the trial court.
Yes. My lord has got it. It is an admitted position Santosh Kumar Saha was the original owner and landlord of the suit premises, and the defendant was inducted as a tenant under him by virtue of tenancy agreement dated 12th of June 1989, and subsequently by registered tenancy agreement dated 23rd of April 1999. The status of the defendant as a tenant in respect of the suit premises is also an admitted position. It is also an admitted position that it has been mentioned in the said tenancy agreement that during the lifetime Santosh Chandra Saha, since deceased, would collect the rent, and after his death the rent would be collected by her daughter Rekha Sarkar. Learned Defense Counsel tried to impress the court to believe that relationship of the defendant with Rekha Sarkar is still existing and Rekha Sarkar is still granting him the rent receipt. In order to prove the same, the defendant produced some rent receipt issued by Rekha Sarkar and Santosh Chandra Saha in favor of the defendant, which has been marked Exhibit D collectively, Exhibit E collectively, and Exhibit F with objection. I am not inclined to give much importance to those rent receipts filed by the defendant in view of the fact that those rent receipts has not been proved by the defendant by calling upon the required witness Rekha Sarkar. It is the duty of the defendant to prove the genuineness and authenticity of those rent receipts, as specific objection has been raised on the other side regarding genuineness. No steps have been taken by the defendant either to call Rekha Sarkar as witness in the suit or made any prayer to record deposition of Rekha Sarkar on commission. In order to counter the allegation habitual defaulter in payment of rent, defendant would have easily called Rekha Sarkar as witness to the cause and proved those rent receipts issued by her, so to establish the fact that he is still paying rent to the Rekha Sarkar as per the terms and conditions of the registered agreement for tenancy for the year 1999. But the defendant deliberately withheld such witness for a reason best known to him. In such premises, the adverse presumption is likely to be drawn against the defendant. But this was the situation prior to the passing of the order. Now, I took out an application under Order 16, Rule 14 for calling upon Rekha Sarkar as a necessary witness to prove the rent receipts. But that application was taken up for hearing, and at the time of hearing, by Order number 51, dated 21st of September 2021, the order was passed. My relevant portion I am placing, my lord. This is a suit for eviction instituted in the year 2015, and almost hearing of the entire argument has been completed. The presiding officer of this court has recorded the maximum number of deposition in the instant case and have heard the argument at length. Now the presiding officer of this court is under the order of transfer. Delaying the proceedings of the instant suit further will cause hardship to the litigating parties both mentally and financially. Learned counsel for the defendant asking the court to act judicially must facilitate the court to act judiciously by concluding the argument on the next date, so that the court may appreciate the evidence adduced by both the parties, both the sides, and the court definitely on the own initiative will call and summon such person if required after appreciating evidence of both sides. The court cannot appreciate evidence on record until and unless argument is concluded. Accordingly, the application under Order 16, Rule 14, read with Section 151 of the Code of Civil Procedure and Section 165 of the Evidence Act filed by the defendant is kept in abeyance till the delivery of the judgment in the instant suit. So there were two things which were guided by the court was compelled to guided by. One is that the presiding officer is going to be transferred or going to retire, and secondly, the court requests to consider whether the Rekha Sarkar is a necessary person to come to the dock to prove the rent receipt or not. But on the teeth of this evidence, on the teeth of this order and the evidence, my lord may kindly see what the trial court came to a finding at the end. internal page 15. I have never accepted the plaintiff as my landlord because by virtue of the registered tenancy agreement, I had been and has been continuously paying the rent to the to Rekha Sarkar as on date. Even the last month rent was paid to Rekha Sarkar, and no letter of atonement has ever been given to me, and that is the recording.
Sister.
Yes, my lord. Yes. Rekha Sarkar, my sister. Well, my lord, my father died 1999. The agreement, registered agreement for a period of 5 years. In the registered agreement, one clause is there. The rent be taken by my daughter. And the said agreement. Yes. So now the point cannot be reagitated again.
Now, by one line, your lordship may kindly seize the last portion. Last but one.
Duration of the agreement. What was the duration of the agreement?
Yeah, just
5 years.
5 years?
5 years.
it is not reflected here.
Yes, reflected. Well, kindly see 112 page. I have annexed the
It was tendered there in the evidence.
in the
Obviously, otherwise.
yes, judgment in the my lord. Judgment it should be.
Where is this?
No, no.
This is the agreement by Chukti Patro, page 109.
109 in my stay application.
That is exhibit A.
My lord, page 112.
Where is the duration?
আমি দ্বিতীয় পক্ষ আমার ভাড়া লওয়া দোকানঘর ও জমি অপর কাউকে ভাড়া বা লিজ দিতে পারিব না। আমি দ্বিতীয় পক্ষগণ আমার ওয়ারিশগণ যতদিন পর্যন্ত ব্যবসা করিতে পারিব না পারিবে ততদিন পর্যন্ত ব্যবসা করিব। ইংরেজি 1/4/99 তারিখ হইতে প্রতি মাসে 1000 টাকা হিসাবে প্রথম পক্ষকে 5 বছর পর্যন্ত ভাড়া আদায় দিব। লাস্ট কোশ্চেন। and প্রকাশ থাকে যে আমি প্রথম পক্ষ আমার মৃত্যুর পরে উক্ত জমি বা ঘরের ভাড়া আমার কনিষ্ঠ কন্যা সুভাষনগর নিবাসী শ্রী প্রদীপ সরকারের স্ত্রী শ্রীমতী রেখা সরকার পাইবে। as in when the lease was expired, tenancy agreement was expired, so Rekha Sarkar has no authority, his authority to be end, because by way of will, after probate, I was the 16th share of that property. He knowing fully well that Rekha Sarkar knows everything. And in the probate, Rekha Sarkar was party. He contest the same. After probate, nothing, my lord.
But so far as the recital goes, my lord.
The agreement for a period of 5 years.
My lord, may I place it once more? ইংরেজি 1/4/99 তারিখে হইতে
আরে
প্রত-
হইতে
হইতে প্রতি মাসে 1000 টাকা 1000 টাকা হিসাবে প্রতিপক্ষকে 5 বছর পর্যন্ত ভাড়া আদায় দিব।
that means 5 years.
মানে
From 1999, 5 years it will end.
মানে মে কাইন্ডলি সি দি
2004.
নেক্সট পেজ। প্রকাশ থাকে যে আমি প্রথম পক্ষ আমার মৃত্যুর পরে উক্ত জমি বা ঘরের ভাড়া আমার কনিষ্ঠ কন্যা সুভাষ নগরী
If the death occurs within 5 years.
নো মাই লর্ড, ইট সেজ আমার মৃত্যুর পরে।
If the duration of the tenancy is 5 years, then what he says is that I will collect rent so long I am alive. That means if during this 5 years, nothing happened to me, I will collect. And if something happens, then my daughter will collect that rent for the rest of the period.
Does not restrict to only 5 years.
That is what it says, the 5 বছর হইতে such and such 99 হইতে 5 বছর পর টাকা আমি জমা ভাড়া দিতে হবে।
মাই লর্ড মে কাইন্ডলি আমি দ্বিতীয় পক্ষ আমার ভাড়া দোকান ঘর ও জমির ওপরে কাউকে ভাড়া বা লিজ দিতে পারিব না। আমি দ্বিতীয়
Not to sublet or
Yes,
sublease anything.
yes. আমি দ্বিতীয় পক্ষ আমি বা আমার ওয়ারিশান গণ যতদিন পর্যন্ত ব্যবসা করিতে পারিব বা পারিবে ততদিন পর্যন্ত ব্যবসা করিব ও করিবে। মানে he will continue as a tenant and continue the business so long he or his legal heirs will continue in possession.
Says that so long I am able to run the business, then myself or my heirs, they will continue and run the business. The difficulty is when the duration for, suppose if it is enforced, then you are not under any obligation to pay rent beyond 5 years. That means if that is the intention, that this rent, this tenanted premises remain in perpetuity, you did not have to pay a single rent. Because the restriction was that you will pay rent up to the period of 5 years.
My lord, in the will which has been probated, the original landlord says রেখা সরকারের সহিত পুনরায় কোনো নতুন এগ্রিমেন্ট করিতে হইবে না, and that has been probated.
No, this is not a will.
This is the tenancy agreement, but pursuant to the will
says that Rekha Sarkareর সঙ্গে কোনো নতুন agreement হইবে না means that if during that period of 5 years, if he dies, then you need not have to renew the agreement. That means he did not create any interest in the property.
no, I have a right, I have no interest over title or interest over the property.
He has not created any interest in respect of a property. You did not allow him to complete the sentence.
My lord, sorry.
In favor of Rekha. Did not. Except maybe for reason that he wanted for 5 years, Rekha should get some money. That is the daughter.
Kindly see the next line. উক্ত রেখা সরকারের উপরুক্ত জমি দান বিক্রয় ইত্যাদি হস্তান্তর করিতে পারিবে না, কেবলমাত্র ভাড়া আদায় করিবে।
Now what does it mean?
I will be only collecting rent.
Not you. You are
Rekha
not-
Sarkar, no, I not Rekha Sarkar will be only be collecting.
will be collecting.
No, I am the defendant. I will be paying the rent to the Rekha Sarkar only.
Your obligation to pay rent is only for 5 years.
But the tenancy agreement in my dispute submission, my lord.
First thing is a rule against perpetuity.
My lord, secondly, my lord, even if your lordship goes by that, my lord, after the grant of probate, I am the defendant, tenant. I am not supposed to know who becomes the landlord or who becomes the I said, your lordship, after the grant of probate, no letter of atonement has been issued to me. Then if I do not pay rent,
You did not raise an issue under section 7. I was surprised that they did not go for 7. All these things would not have come.
But secondly, what has fallen for your lordship on the
These are
last?
very, I do not know, it's a blunder. One can perceive in this regard.
So far, another point that has fallen from your lordship, my lord, whether the suit for recovery of possession
In case of any dispute, Yes.
My lord, may kindly see, I am placing at the cost of repetition. The tenancy agreement says that আমি দ্বিতীয় পক্ষ mean I am the defendant. Defendant. My lord, the tenant. আমি দ্বিতীয় পক্ষ বা আমার ওয়ারিশগণ যতদিন পর্যন্ত ব্যবসা করিতে পারিব বা পারিবে ততদিন পর্যন্ত ব্যবসা করিব ও করিবে। But it does not limit to 5 years. May I respect subject to what your lordship?
What is the meaning of this word?
Subject to what your lordship will interpret, my
What is
lord.
You have read one portion, then you have to read this portion as well. What is the meaning of?
May I place the paragraph once more? Thereafter it continues.
ইংরেজি ১/৪/৯৯ তারিখ হইতে প্রতি মাসে ১,০০০ টাকা হিসাবে প্রথম পক্ষকে ৫ বছর পর্যন্ত
ভাড়া আদায়
আদায় দেব। What does it mean? And what will happen to this? What does it mean? Now, another legal question. If there is some inconsistency or discrepancy in the earlier portion and the latter portion of an agreement, which will prevail? Earlier or a latter?
My lord, so far as the probate is will is concerned, the latter
Not
portion.
will, sorry.
I'm saying, your lordship. So
Agreement. I'm talking about the agreement. If there is some inconsistency in the agreement, which cannot be reconciled between one portion appearing in the earlier part and the latter portion, then which will prevail? Earlier or a latter?
my lord, the document is
Let us
just the
go by inconsistency. Yeah,
document is
but
just the
cannot be-
converse of the will. But so far I gather knowledge.
One has to harmonize. That's the first duty of
Yes.
the court, to harmonize.
Yes.
Suppose I'm extreme case, it cannot be reconciled. Then what?
But in cases of documents, the earlier portion, in
cases of
documents and deeds and documents, but in cases of will, it is the latter, what will come at the lane, that will has to be taken into consideration. That much I have gathered knowledge, my lord. So far as the will is concerned, the probate portion, will portion is concerned, the last intention, what is reflected up to the last line. If there is a
I'm not talking about the will. If agreement or a deed. Let us go. Very specific now. Don't get confused. You cannot reconcile two portions. Which will prevail, earlier or later? Check.
well, earlier portion will come. Latter portion. But that can be in one way, my lord. I can also say, my lord, the document has to be read in the entirety.
That is what I am again saying. I am conscious. The court must read the document as a whole and harmonize all the portions.
And the true intention.
But I am saying that even while doing so, court cannot harmonize it.
My lord, kindly see, my lord.
Cannot reconcile one to
Kindly
another.
see,
Then
my
what
lord.
will happen?
So far as that line is concerned, subsequently it says, প্রকাশ থাকে যে আমি প্রথম পক্ষ, that is the owner, landlord, আমার মৃত্যুর পরে, whenever he dies,
So now we have to reconcile.
উক্ত
That
জমি,
what he meant
yes,
is, if the duration is 5 years, then this portion has to be harmonized, that if during the period of this 5 years, if I die, then my daughter will be entitled to collect rent, but will not claim any rights in respect of her property. So this has to be harmonized in that during that 5 years. After
but he died much later to the much after the 5 years. 99 executed, the owner died much later after.
No. 99 died. died on 30th September 1999. Kindly see page 2 of the trial court judgment. The said Santosh Chandra Saha died on 30th September 1999, leaving behind his son, plaintiff, and Ganesh Chandra Saha, 5 daughters. The legal years of that.
Then also, my lord, my interpretation will be, if he dies after execution of the document, but the last portion it says, প্রকাশ থাকে যে আমি প্রথম পক্ষ আমার মৃত্যুর পরে উক্ত জমি বা ঘরের ভাড়া আমার কনিষ্ঠ কন্যা সুভাষনগরী শ্রী প্রদীপ সরকারের স্ত্রী শ্রীমতী রেখা সরকার পাইবে।
This intention has
It was never the intention to
again as a lease is for a duration of, let us think, a lease is for a duration of 10 years. Then the tenant cannot claim right after the expiry of 10 years. The lease deed contains that so long I am alive, I will collect the rent. After my death, my daughter will collect the rent. What does it mean? Then if both this has to be interpreted, then the harmonious construction says that the tenancy was for a period of 10 years. Right to collect is restricted for a period of 10 years. What he intended is that during this 10 years, if I die, then at least the rent will be collected by one of my daughter. That collection of rent, that's right, is up to the period of 10 years, not beyond that.
5 years. 10 years. 5 years.
Don't raise their hand.
The 5 years, this is the agreement, 5 years.
my lord একটা example দিচ্ছি।
What? For example, okay.
You don't know when it will turn out to be a boomerang. Take your seat. Yes. So this is what a harmonious interpretation can be given. Not beyond that. And in an earlier part, it has been said that it is you are liable to pay rent of this for a period of 5 years. What does it mean? That the tenancy was for a period of 5 years. The person
No,
who
it can
has
also
right
be-
to remain as a tenant, can he pay rent? What are you talking about? So she's collecting. The duration of that opinion perpetuity cannot be done. Is a perpetuity.
Now, the second question, what has fallen from your lordship on the earlier occasion was that whether the suit is at all for recovery of possession on reasonable requirement can be maintained by the present plaintiff. Cannot be. Because
But there is no fetter on the part of the court to treat the suit under the general law and treat that notice under section 66(4) as a notice under section 106. No defense.
but so far as the notice been given and the suit be instituted under the specific provision.
No, it's not required. The power of the court is there, eminent. You want a judgment? I can give you multiple judgments on this.
No, my lord, I am not on that, my lord. I am so far as the suit for recovery, a prayer for recovery of possession, my lord.
The condition is the notice. Notice has already been given. Whether the notice is captioned as 6(4) or 106 immaterial. It's a notice showing their intention that you have to give possession. That's all. Nothing more than that.
But so far as the remand order is concerned, my lord, the remand order relates to.
The Rekha will come and say that I am collecting the rent.
Yes.
Was she entitled to collect the rent on the basis of this interpretation of the agreement?
Whether I am at all a defaulter, that much I can prove that I have tendered rent because no letter of atonement was given to me.
Question of status.
Yes.
Rekha does not have a semblance of right title and interest in respect of the property where the tenancy is situated. Even this agreement is corrected. The Rekha has been given a right only to collect rent, not to claim any right in respect of the property.
Only to collect rent.
Correct. Now the question is that he is admittedly now the owner. Rekha has lost. She was an objector to a probate case. Her objection was turned down. Probate has been granted in his favor. They were two brothers. They got equal share. One of the brother executed deed of gift in his favor. Now he become an absolute owner. Can an owner is denuded of power to recover the possession from the tenant? I'm asking. Is it a perennial tenant? Perpetual tenant? For all time to come? Having no right to sue? And the Rekha has got a right or elevated the right above him? Having no semblance of right, title, and interest in an inch of the property. What would happen? Tell us. Where this gentleman will go?
Only
You
one.
are not liable to pay beyond 5 years. From 2004, you can say, I am not liable to pay a rent in terms of this agreement. I have paid up to 5 years. Now I remain perpetual tenant without payment of rent. Is it acceptable?
No. So far as
If we go by a literal interpretation of the clauses say so.
no, it is not a case that the payment has not been made.
I am again asking, your liability was restricted to 5 years. Only 5 years rent you will pay.
But what about the clause? May I just put it to myself?
I'm asking you. I'm just saying. Suppose if you say that this is an agreement which says Ingriji Actchar 1999
No, the preceding line. Kindly see the preceding line.
প্রতি মাসে 1000 টাকা হিসাবে প্রথম পক্ষকে 5 বছর পর্যন্ত ভাড়া আদায় দেব।
Kindly
That
see the
means thereafter, suppose if you remain, first প্রথম পক্ষ is still alive. Let us think of that. Can প্রথম পক্ষ institute a suit against you after 5 years that you pay me a rent? You will say this is the clause. The clause you have restricted the payment for a period of 5 years. I have paid the rent for the up to 5 years. I'm not liable to pay it for the 5 years. You can't claim any rent. Can you not say? If you go by so strict literal interpretation of the clauses. Accept. No difficulty. Can he claim? Beyond 5 years. If he cannot, then perpetual tenancy. Unknown in the law. Rule against perpetuity.
But only thing, may I just indicate to Lordship, so far as the order of remand.
We will be. It is matter of dictates.
Sick, my lord. I have talked to
Come
Mr.
to court, he is having fever. He went to Sandiniketan, in fact, in the weekend. And thereafter he came back with a high fever. Doctor advised him bed rest.
Only I'm praying before your lordship. This matter was substantially heard before your lordship, my lord, and Mr. Mitra has almost completed his argument. My lordship will kindly take it on Thursday, my lord. With folded hands, I'm praying before your lordship.
Keep it on Thursday. I have no.
Very well, my lord.
Keeper is there, so
No, only I'm praying
we
before your lordship.
expect him to recover. Expect him to recover.
Thursday in the morning, my lord, if your lordship takes on the first hour, my lord, if your lordship takes.
Why? Take it up. Take it up.
At 2 p.m.
Obviously.
Sorry, my lord.
Yes. Yes. There he is. He's gone. We are directing him to rehear the appeal on merit. He has not really considered all the points.
My lord, regarding the remand question,
Only the order of remand. So
Yes.
remand was not really warranted.
yes,
So, but he has to deliver a judgment on merit.
but the trial court has passed the merit.
Okay, so then what is the
Appeal
utility of the
court
first-
on the point of part
Correct.
allowed.
Correct. If it
Yes.
is set aside, then he has to deliver a judgment on the merit.
Well, part allowed,
Part
and my
allowed
lord,
means what? Remand.
remand only that point. Other
Yes.
point affirmed.
Where is that affirmation?
Kindly see. Other point remand, other point affirmed.
Where is that?
Kindly see page 12. That the instant title appeal being such and such, my lord, same be allowed in part on contest, thereby the judgment dated such and such, decree passed by the court is set aside. Resultingly, the case is remanded back under trial court for deciding application under order 64 reduction.
So there was no judgment on the other, whether there is a reasonable requirement, there is anything, whether there was a default, all these things he has to affirm.
My lord,
He has to
they
affirm.
prefer an appeal only that point. They prefer an appeal only that point regarding order 16 rule 14 of the Code of Civil Procedure. But the Supreme Court says, my lord, Supreme Court says the paragraph 17, only that point be canvassed by the Honorable High Court.
That is for the purpose of considering the order of remand by the second appellate court like a high court.
Yes.
But it is a duty of the first appellate court to consider all the issues which are there.
They have,
Because
they have
it is-
considered all
Where
these
is
they have
that?
considered.
Where is that? I am looking at it. That where he has said that this ground, this
Well,
issue
kindly
is
see
correct.
page 11.
Just let me, instead of taking your assistance, let us go through the order.
Yes. Then, my lord, I will argue again.
Just, you'll have to. So he has not said anything on the merit of those issues regarding the default, the reasonable requirement.
Well,
Nothing, not a
Page
single
11,
whisper.
page 11.
Please read that. I do not find.
In considering the impugned judgment in the light of the facts, circumstances, the issue framed as well as the evidence adduced, it is found that the issue number 5 as to whether the appellant defendant is a habitual defaulter, and issue number 6 as to whether the suit is bad for defect of parties have not been dealt with by the learned trial court correctly.
So default ground also he has not.
Because, well, then, my lord,
But reasonable requirement, he has not said anything, because I have seen the entire finding is really circling around
I
this
am asking
particular
myself, remand court
witness.
can, whether the remand court can other point can re-agitate. Well, this High Court,
Sir, this is only for the purpose of High Court. The High Court will say that there was no necessity for remanding the matter. Rather, there was sufficient material before the first appellate court to decide the matter on merit. So the appellate court has to decide the matter on merit.
no, appellate court decide the merit
No,
in part,
no,
only the this
no,
part.
no.
Then,
it
my
is
lord, your
not.
lordship adjourn the
Let
matter
us,
after vacation.
sorry, Mr. Giri. That's enough.
No, then my lord, I will
Sorry,
argue again,
that's
my lord.
enough.
But then, my lord,
That's enough.
I am not praying before your lordship. Give
Come.
me chance to.
Come.
Let me finish, my lord. Let me finish.
You have finished. Then the
No.
cost.
No, they have
Cost.
given the.
Not a single whisper on the reasonable requirement. Not a single word has been said in the reasonable.
But trial court judgment.
Trial court has simply proceeded on the basis of a defect of parties, or whether there was any necessity to call that witness. That's all. And the court has said that it remained undecided.
Whether, I'm praying before your lordship, whether the remand court can, I am asking myself. Remand court cannot. I am giving the judgment.
After all, let us give us an opportunity to deal with the judgment of the Supreme Court.
Yes.
And what the Supreme Court says.
Yes.
Let us.
Supreme Court says,
that is your understanding. Let us deliver a judgment from our understanding.
I have my understanding.
So we have some knowledge. So let us decide it.
No, then my lord, your lordship can adjourn the matter. I will argue the next day.
No.
No, I'll produce some judgment.
What?
I'll produce some judgment.
What?
Next date, my lord.
What judgment? So show us.
Regarding the remand, as in when the first appellate court remand the matter,
Correct.
only specific point.
Correct.
High Court cannot interfere other point.
No. So we are saying so. We are saying so. Who says that we are not saying so?
No, other point means reasonable requirement.
Alright.
Only default ground is disputed. Only default ground is disputed because the agreement. No, but let me finish, my lord. Very, my lord, I am not never hesitate this point, my lord. But such types of argument, my lord, never. Your lordship can adjourn the matter.
No, we are dictating it and accepting your argument.
No.
That we will not look into the other grounds.
Regarding reasonable requirement, other point, my lord, your lordship kindly, only the point whether the application was disposed of or not. Trial court come to finding undecided, whether it is legally or wrongly. Here, my lord, I am ready. Coming to the written statement filed by, your lordship can pass the judgment against me or not, that is no question, my lord. I pray before your lordship, I may be submit something.
Accepting your contention that it is not a fit case of remand.
Yes.
Again, please consider.
Yes.
Open the shutter of your closed mind.
Yes.
Please open it.
Yeah.
What is appellate court or the second appellate court, let us see like a high court,
Yes.
is supposed to do? Will confine whether there was any necessity for remanding the matter to the trial court on these issues.
Only one issue.
If we find there was no necessity, then second question is, what is the duty of the first appellate court under section 96 of the code?
The 96 says, my lord,
please come.
Yes.
This is the first appeal under section 96, where the entire writ it is at large.
Yes.
It is a duty ardent and bounden duty of the appellate court to decide all the issues which were involved in this and to answer it. Because it is the last court of fact and law. It is not the court of law only or of fact. The last court of fact and law. The High Court is not a court of fact. The High Court entertains under Section 100 the appeal, provided the substantial question of law is involved in the proceedings. Substantial question of law does not mean every question of law.
Here, substantial question of law should be
Again,
framed.
it does not say that every question of law. It should be a substantial question of law. Read from Santosh Hazari's judgment of the Supreme Court. Till date, it has been consistently held that there is a distinction between a question of law and a substantial question of law.
Yes.
The Supreme Court has defined that what is it. So, in that event, it is a duty of the first appellate court to answer issues. What are those issues? Whether there is a requirement, have you pleaded it, you reasonably require the premises, whether you are in possession of reasonable suitable accommodation, all these things the court has to enter into and return its finding. Independent finding beholds the trial court judge. Because he is the last court of fact and law. He has to go into the facts. He has to say that I find that this issue has been correctly decided, you are entitled. All these findings must come. This is what is conspicuously absent here. If we say, then we'll have to say that here, within a time frame, decide on all the issues.
But subject to correction. As in when the defendant, appellant, preferring first appeal, only one ground that the application is not disposed of by the trial court. On that ground, remanded.
Of appeal contains all the grounds, including reasonable requirement, including default, including the defect of.
But that ground be affirmed by the appellate court. Trial court affirm the part of the judgment.
If there is no finding which is made, not a single word, sentence is used, do you think it is an affirmation? I am asking. When it is your duty to decide, under the law, if you say, I can give you plethora of judgments.
My lord, is enough.
I can give you up till number of judgments which says that what is the duty of the first appellate court.
My lord, one thing.
Realizing.
My lord, one thing, subject.
And you are really putting a spanner in dictating the judgment.
No, I am not dictating the judgment.
But then do it.
My lord, I am.
Prepare yourself.
Yes.
Matter to appear 2 weeks after the vacation.
But don't be amiss, my lord.
No,
I am trying my best.
No, we are. If you do not realize, then we are. You are passing an order in your favor and you are putting a spell. So, go there. Go there.
My lord,
no, we will not hear them.
My just love
no, good sense has
but God, your lordship amiss me then, my lord.
No, we are not happy.
Then my lord, I am praying apology. As your lordship did pass the order.
It was not expected from you. That's why we are unhappy.
I am trying my best. Your lordship.
You are trying, but you are really doing something. You are saying something which is absolutely contrary to law.
Real, your lordship pass the order. For the interest of the client, your lordship can. I am praying apology. As your lordship pass the order. I am accepting this. Only একটা মারার জন্য ঝামেলা করলে লাভ কিছু না। So we are coming regularly. So we are the bar and bench, my lord, relationship.
So good, but the bar must understand the bench. Bench is understanding the bar. But
from the bar, we can. From the bar, we can. Your lordship, while that side, your lordship can.
Then what happened?
Very well, my lord.
It reminded me of the first day.
No. Mobile.
Huh?
Oh, that is very Memorable day, my lord. Yes, lordship, I am paying apology, my lord, an apology. I have tried, that is why I am argue, your lordship can pass the order. For the interest of the parties. Yes, my lord, time.
15th of January, they will not adjourn and then everything is there.
Yes.
Here.
Regarding rain discourse, sir, your lordship, Attanam judgment be.
Attanam is for the purpose of stay.
Very well, your lordship. Very well, I'll try my luck. Lower court, I'll try.
Stay has been over. It is over. Then
Very-
Attaram. What
very-
Attaram will do?
No, ঠিক very আছে আর বাড়াচ্ছি না ঠিক আছে no problem. I think I will got yes.
One thing I should pray, my lord. They have proceeded with the execution. Execution has been.
Did you secure the stay before the first appellate? Was there any order of stay in the first appeal? If it is not, can be enforced. If it is not, it is not.
As you wish.
Again, my lord, I am paying apology. Don't be amish.
Convince my brother. If he says,
Yes.
don't take it away, let my brother say. I'll take it.
But it is your habitual, my lord, regular practice, my lord. We are trying my best. This, that, my lord, this way.
For a first an officer of the court, you have to assist the court in coming to a correct decision. Maybe you protect the interest of your client. But the
I have tried.
For the towards the court.
Your lordship knows, my lord, nowadays landlord tenant decision, my lord. So your lordship kindly frame time be framed. Time be framed. Without giving any adjournment for the parties. For the interest of the litigant.
You have other cases in other court.
Now, I judgment is my lord. I
The instant appeal arises from an order of remand passed by the first appellate court in title appeal number 26 of 2015. What is the number of the appeal? Because the certified copy, there is a confusion. It is 2015 or 2021?
2021.
Huh?
Title appeal number 26 of 2015.
15 or 2021?
2021.
With title suit is
High
2015.
Piece of 2015,
yes.
I know. But what about title? Because certified copy says
2021
26
of
of,
5
20,215. So 20,000 year has not come.
Yes.
What is this? Either 2021 or 20.
My lord, degree itself, my lord, 2020 or 2021. But degree, kindly see degree.
26 of 2020. Page 87.
ওই পাঁচটা কিসে পড়েছে কি
Wrongly typed.
The eviction of a on the ground of default and visaged under section 6 of the Listing of Insolvency Act 1997. It is stated in the claim that the property originally belonged to his father, namely Santosh Chandra Saha, who during his life entered into agreement of tenancy, which was disturbed with the registering authority, inducting a dependent respondent in respect of a shop room at a monthly rental of ₹1,000 payable according to custom. The plaintiff traced his absolute right title and interest in respect of the supremacy on the strength of a will made and published by Santosh Chandra Saha since deceased, which is duly probated by a computer. It is not in dispute that the original owner left behind him surviving 2 sons and 5 daughters. Santosh had how many? 2 sons and 5 daughters.
5 daughters. But will was executed in favor of
Oh. But by virtue of a will, the entire property was bequeathed upon the 2 sons, thereby excluding the daughters to inherit the estate left by them. The application for probate application that came was resisted by 1 or more daughters by lodging a caveat and filing an affidavit support thereof. Come on. But such objection could not be sustained, and the application for probate was granted. Subsequently, the brother who was beneficiary under the said will executed and registered a deed of gift in respect of his share in favor of the plaintiff. It is further stated that this was served upon the defendant respondent, which would be evident from the fact that the reply to such notice was given. Which is a condition precedent for institution of suit for on any one of the grounds enumerated under section 6 of the Act. The plaintiff averred that the accommodation available to him and his family members are scanty, and therefore he reasonably requires the suit premises for him as well as for the benefit of the family members. It is further the defendant respondent has neglected to pay the rent in respect of the shop and therefore committed fault exposing him liable to be evicted from the suit premises. The defendant respondent took a defense that there is no relationship of landlord and tenant, and therefore the suit at the behest of the plaintiff appellant is not maintainable. It is further averred that the tenancy agreement executed by and between the original owner and the defendant could reveal that rent shall be collected by the said owner during his lifetime and after his death. The youngest daughter, namely Rekha Sarkar, shall collect the rent. And in fact, the rent is being tendered and paid to the said Rekha Sarkar. On the prospectus of the opposite stand taken by the respective parties in their meeting, several issues were raised, including an issue relating to the relationship of landlord and tenant. Including the relationship of landlord and tenant. And the trial court proceeded to determine the issues after inviting the parties to adduce evidence. Interestingly, an application under Order 16, Rule 14 of the police dispute was taken out by the defendant respondent, inviting the attention of the court that the vital witness, being the sixth Rekha Sarkar, should be examined in order to conclusively determine the issue relating to the relationship of landlord and by an order number 51 dated to the date of an order number 51
21st September 2021.
and order number 51 dated the court, the trial court took up the said application but did not decide the same conclusively, as the concluding portion of the order revealed that the decision in the said application was taken in advance till the suit is till the final hearing of the suit is taken up. The trial court decreed the suit decreed the suit as the plaintiff applicant as the plaintiff applicant has been able to prove the grounds enumerated there, which was assailed by the defendant respondent before the first applicant. The first appellate court remanded the matter as according to it, the issue as to whether the suit is bad for defect of parties as well as the issue of default in payment of rent. Has to be decided on the basis of an evidence of the said Rekha Sarkar. The trial court further held that since the application under Order 16, Rule 14 of the Court of Procedures filed by the defendant appellant was not finally decided by the trial court, the impugned judgment is defective, infirm, and cannot be sustained as any interlocutory application remain pending, any final judgment shall be bad and illegal. The court thereafter, the first appellate court, remanded the matter, directing the trial court to decide the application under Order 16, Rule 14 of the Code of Procedure after hearing both sides and by passing a reasoned order, and thereafter to pass a judgment and decree as well. Mr. Giri, the learned advocate for the appellant, vociferously submits before us that the jurisdiction of the High Court in relation to an appeal against the order of remand is limited, and the High Court should not travel beyond the boundaries of the order of remand, or in other words, the grounds assigned by the first appellate court while remanding the matter to the original court, and should not venture to decide the other issues. In support of the aforesaid contention, the reliance is placed upon a judgment of the Supreme Court rendered in Narayanan versus Kumaran and others, reported in 2004, Volume 4, SCC, page 26. It is further submitted that in the penultimate paragraph, the trial court in fact disposed of an application under Order 16, Rule 14 of the court, and therefore the finding of the first appellate court is erroneous and perverse, being contrary to the records. On the other hand, the counsel for the defendant respondent submits that the said Rekha Sarkar is a vital evidence, a vital witness who can throw light on the collection of the rent on a monthly basis upon issuance of the receipt in terms of the entitlement vested upon her on the basis of a tenancy agreement. It is sought to be contended that the original owner, in unequivocal terms, agreed that during his lifetime, that he will collect rent during his lifetime, and after his death, the said Rekha Sarkar, being the youngest daughter, shall collect the rent. It is thus submitted that the relationship of landlord and tenant has not been established, as the said Rekha Sarkar is regarded as a tenant, as a landlord in respect of the tenanted shop. Such being the points asked before us, we do not find any difficulty in the proposition of law enunciated in the said judgment of the apex court, as noted above. that the moment the appeal is filed under the provision of Order 43, Rule 1 within bracket 2 of the Code of Procedure, the court shall confine its consideration to such portion of the judgment and slash order of the first appellate court which relates to the order of remand to be passed. The relevant excerpts of the said judgment is quoted as under. The court paragraph 17, 18, of the said judgment. It is no longer a centegra that the state of determination under Order 43, Rule 1 within the view of the court is restricted to a findings relatable to an order of remand, and the High Court should not reopen reopen all such issues which are involved in the said appeal. It is further held in the above noted decision that the scope under Order 43, Rule 1 within bracket 2 of the court is somewhat akin to Section 100, where the court should avoid the reappreciation of the evidence or the facts, but should confine its consideration on the findings of remand. On a meticulous reading of the entire judgment, we find that the appellate court was swayed by the fact that an application under Order 16, Rule 14 of the Code of Procedure was kept pending and remained undecided, and therefore the court ought to have decided the trial court ought to have decided the said application before it embarked its journey to a final destination of the suit. Though the appellate court noticed the order number 51, wherein the trial court kept the decision in abeyance, but overlooked the material part of the findings returned by the trial court, which without any ambiguity relates to the disposal of an application in the following. Quote, I am not inclined to discuss the other case laws as submitted by both the parties, as either they are not relevant or the facts and cases are not applicable to the institution. I also like to state that Rekha Sarkar is not a necessary party to this case, as already discussed, and so this court is not inclined to call her as a court witness. And accordingly, the petition filed by the defendant that appeal is considered and rejected. It goes from the aforesaid observations, the finding of the first appellate court that the said application remained undecided runs counter to it and may be termed as an error apparent on the face of the record. Be that as it may, the finding of the first appellate court is perverse to the effect that it did not notice the fact that they said application was rejected by the trial court. Stop. The next one. The question whether the Rekha Sarkar is a material witness or not has to be considered in the perspective of the disputes and of the issues involved in this dispute. Both parties have relied upon the tenancy agreement executed by and between the original owner and the defendant. The meaningful reading of the clauses and or the terms incorporated therein leaves no ambiguity that the tenancy was for a duration of 5 years. As the defendant respondent was obligated to pay rent during the currency of the said tenancy. Though it is indicated therein that so long the original owner remained alive, he will collect the rent. And after his death, the youngest daughter, namely Rekha Sarkar, shall be entitled to collect rent. But the court must read the document as a whole in order to gather the intention of the maker or a parties to the said agreement. All the terms of the agreement should be reconciled, being complementary to each other, and it is a first and foremost duty of the court to harmonize the aforesaid terms in a pragmatic manner. Any inconsistency and or discrepancy appearing in a different clauses, the canon of interpretation in this regard is required to be pressed in action. Stop. The agreement is required to be read as a whole and not in a piecemeal, as every segregation is susceptible to create a confusion or may defeat the very intention of the contracting parties. The The counsel for the dependent respondent is very much vocal that the moment the owner indicated in the said agreement that he will collect the rent during his lifetime, and after that, and after her demise, his demise, her youngest daughter, Rekha Sarkar shall collect, it whittled down the earlier part of the recital. In other sense, it is thought to be contended that the tendency is of perpetual and not perennial in nature.
No further agreement is required. It is written.
And therefore, in terms of the said agreement, the Rekha Sarkar is collecting them. We do not find aforesaid contention having any substance in the well-known principles of law that the tendency created in respect of a part or a portion or a part or portion of the property is subject to the law governing it, provided such tendency comes within the purview of the Rent Restriction Act. The moment the parties have limited the period of tenancy and the liability ceases upon expiration thereof by influx of time, the other clauses has to be understood and understood in such perspective and cannot be interpreted to frustrate or render such clause ocious. The intention was laudable and evident that during the currency of the tenancy, limited by a period of 5 years, and if the original owner remained alive during such period, he would continue to collect the rent. And if, God forbid, he died, if he expired, the youngest daughter can be entitled to collect rent, which cannot stretch beyond the duration of the tenancy. The moment the tenancy comes to an end, upon expiration of period limited thereby, it immediately severed the relationship of landlord and tenant, or a lesser or lessee. And it is contractual as well as the statutory duty of the lessee to deliver the possession to the owner / lessor, as envisaged under section 108 of the Transfer of Property. We thus do not find from the terms and conditions as well as the recitals of the agreement that the Sid Rekha Sarkar is a vital is an important witness for the simple reason that even if it is proved that she has collected rent or continued to collect rent, such right ceases upon an expiration of period of tenancy and cannot continue beyond, say, stop. We thus do not find. Now, few of the above, the finding of the first appellate court is liable to be interfered with, which in fact is done by us. The same is hereby set aside. Since the entire judgment, the order of remand was hovering on the circumference of the application under Order 16, Rule 14 of the court having not decided, there is no finding returns on the other issues or the merits in relation thereto. The first appellate court, being the creature of the statute, is required to return its finding on all the issues afresh, being the last court of fact and law. The entire issue become at large, and it is a ardent duty of the first appellate court to decide the appeal on the basis of the evidence adduced by the respective parties and the arguments so advanced. Since the first appellate court has not decided the other issues, more particularly issue relating to the reasonable requirement and default, we feel that the matter is required to be remitted to the first appellate court to reconsider the said appeal by recording proper reasons. Stop. Accordingly, the first appellate court is directed to rehear the appeal after affording an opportunity of hearing to the respective parties, and shall dispose of the same on or before 15th January 2024. Stop. It goes without saying that in order to adhere the time limit indicated here, indicated here in above, being mandatory and peremptory, the first appellate court shall refuse unnecessary adjournments to either of the parties. Even if the first appellate court, even if in the event the first appellate court finds that the adjournment cannot be refused because of the grounds taken therein, which is unforeseen and unavoidable amount. The endeavor shall be made to fix the matter on a day-to-day basis, so that the time limit set forth herein above is strictly complied.
But the order should be communicated in my cost. I will pay the special messenger cost as your lordship. Because after the server.
Let the judgment and order passed in the instant appeal be immediately communicated to the first appellate court through special messenger at the cost of the appellant. Stop. Such cost shall be put in course of this day.
No, in course of 2 days time necessary.
Put in by Friday.
Great. Grateful.
Oh, the cost of since the several interruptions were made while commencing the judgment, dictation of the judgment, we feel that the cost of rupees 3,000 be imposed on the appellant. By the appellant, the advocate, senior counsel.
At the time of dictation, my lord, I never, my lord, interrupt, my lord. Before starting the dictation, my lord, I have some argument on behalf of my client. I have tried, but at the time of dictation, not a single word I have not, my lord, uttered. So kindly consider it. At the time of dictation, I have never. It is my habit. I have learned from my senior. At the time of dictation, don't disturb the court. So my lord, kindly condone the cost. It is my. No. Very. Your lordship, kindly.
Let's call the next matter.
Cost be deleted.
My lord, your lordship,
Grateful.
directed me to come back at 2 regarding item number 1, my lord, extension of interim order. Extension of interim order, item number 2, your item number 1. I have prepared the supplementary affidavit. Supplementary affidavit is. দুটোই রয়েছে, দুটো কপি চাই? চলে আনবে। সাপ্লিমেন্টারিটা রয়েছে, না ইয়েটা নিয়ে এনে দিচ্ছি। করলো না তখন, এটা তো হবে না আর।
Operative for a period of 10 weeks.
পরে দিয়ে দিচ্ছি from 16th of October, my lord. It is going to expire on 18th of December, my lord.
He stated that he refused.
My lord, yes. In the supplementary affidavit of service, my lord, I have stated.
There is the other.
And my lord, in the
matter has come up for extension. Wicket 66. By an order of the proceedings of the execution case for the state for a period of 10 years. For until further, and the applicant was directed to serve the copy of the application as well as communicate the said order to the respondents to file the evidence and the written. Today, the appellant was further directed to communicate the said order and the serve the copy of the application on the money that proceeding the responsibility. The affidavit of service filed today reveals that the postal article sent to the respondent returned with the postal remark left As there was no such person in the said address. According to the learned advocate for the appellate, the cost title of the execution case depicts the same address where the postal article was sent, and the respondent is avoiding this. Furthermore, in the supplementary affidavit, the service was attempted upon the learned advocate representing the respondent, and it is stated therein that the said the learned advocate refused to accept the service. In view of the above, let the interim order granted on 16/10/2023 be extended till the end of January 2024 or until further order is issued. The appellant is directed to communicate this order to the respondents immediately.
Grateful to your lordship. Advocate on oh, अच्छा नाम दे दीजिए.
Yes.
Your lordship's kindly. I appear for the appellant, lordship. Lordship, I'm led by Mr. Aniruddha Chatterjee. He's there online.
My lord, there is a problem in this matter. My lord, your lordship remembers this. Your lordship heard me at length. When I told your lordship, my lord, that their service was complete. My lord, I produced before your lordship, my lord, the postal endorsement that the addressee has received it. But on that very day in the evening, my lord, the entire postal envelopes have come back to us with the endorsement incomplete. So I need to tell that to your lordship, my lord, before I proceed with the matter. So I don't think, my lord, the service is complete. This is the matter where your lordship wanted us to bring, my lord, the video of the premises in question, where, my lord, the construction was happening. A better video, my lord. I had shown your lordship a photograph where I had shown your lordship that the other side was making construction, my lord, on my boundary wall. And I had shown your lordship pictures and, my lord, rather pictures, and your lordship wanted a better, my lord, photograph of the entire construction. But I have to tell your lordship, my lord, that the service is not complete.
The Prodhan was served by hand. That is there.
Prodhan, my lord, is the person who might have given, my lord, a sanction plan, but the actual defendant, my lord, has not been served. Could not have been served. We wanted to, my lord, give them by hand, but even there, my lord,
there is insufficient address.
It is the same premises.
Same
Not
premise. Same premises, and the person who is there, my lord, refuses to accept it by hand.
Also, the letter to the Prodhan has come back as insufficient address. Even to the Prodhan, it has come back as insufficient address. The Gram Panchayat Prodhan, that has also come back.
Something happening. I don't know, my lord, what's happening.
But
and every day, my lord, they have started their construction, my lord. The rate at which they're doing it, they've doubled it. Lord, I was praying for an ad interim order, Lord, in the meantime, and I shall serve and come back. Because there's something wrong somewhere, my lord, which is happening. Mr. Mukherjee, may hand over the photograph that you have.
Photographs are with my lord. I have the videos on my phone, as my lord asked.
He wanted a
a clearer picture. That's the video, my lord. We've taken a video, my lord. We may airdrop it to your lordship, my lord, if your lordship so pleases. That's what your observation was on the last occasion.
Probably not, because our device is not a iOS compliant.
My lord, I'm sorry, my lord, but I must have, my lord, misunderstood.
Yes, airdrop will always is only
iOS. It's iOS. I'm sure, my lord, your lordship has an iOS device somewhere around.
Oh, not provided.
High time, my lord.
Provided.
But I'm sure your lordship has it on.
No, our system also does not.
Your lordship has, my lord, the Android one. I'm sure Mr. Mukherjee can arrange for that as well.
No, why we will? Can it be? Is it possible in the chat box?
Because chat box.
I may just.
May he just hand over his device so that your lordship may see it. And I'm sure, my lord, he's not going to suffer the same fate that I had suffered at your lordship's hand.
Only your concern is that anything which is constructed on a boundary wall.
Yes, sir.
Other places you are not concerned with that.
That's part of his premises. I don't have a problem with that. On my boundary wall, he cannot construct. And that too, not leaving any space between the two constructions.
That is a matter to be decided elsewhere by the but now is that they cannot touch upon your boundary wall or make any construction over it.
I bow down, my lord. That's it. Nothing more than that.
This confusion was there. Confusion was there.
If I may just hand over my phone, my video is clear, Lordship. If I may hand over my phone, the video is very clear, Lordship. Because
I just hope Mr. Mukherjee doesn't suffer what I suffered at your lordship's hand.
but going to press the play button.
No, it does not appear that he is really making construction on your boundary wall. He is just making a boundary wall adjacent to your boundary wall.
Lordship, there is without any space remaining.
That
Lordship,
is
they
a
made
different
it
issue that
is
we
what-
will decide on that. But on the other hand, on the last occasion, it was said that on my boundary wall, they are raising construction.
Lordship,
So
that is our
this was the
boundary wall.
photographs which were shown.
So that
It
is the
appears
boundary
that on your boundary wall, they were putting a brick and then making a construction.
By the side of it.
Oh,
By
this
the
is
side of it.
your boundary wall is there. They are not leaving any space, but they have put the brick.
Not adjoining it. Adjoining. There's not an inch of space between the two.
This is what is anyhow. Let us see the first we attempt the service.
I took care of it.
My brother has a more, I would say, the good eyes than me.
I'm sure my lord used to play cricket, my lord, for some point of time.
Yes. Yes, it is submitted by the counsel for the appellant that the service was attempted upon the respondents in terms of the order passed by this court. And after the filing of the affidavit of service on the last occasion, the postal articles were received containing the endorsement that containing an endorsement of insufficient address. It is submitted that the respondents are managing the service so that they can merrily proceed with the construction work, which in fact saw a rapid pace since the last order is passed. Our attention is drawn to the photographs and the video taken in order to show that the constructions are made infringing the rules or the statutory provisions, and also impairing the boundary wall of the appellant. Considering the nature of the submissions as well as the statements made therein, and the fact that the service could not be affected, we feel that the presence of the respondent can be secured if the service is affected through the local police station. We therefore direct the advocate and record of the appellant to lodge the envelopes containing the applications filed in connection with the instant appeal with the officer in charge of the which police station?
Lordship, the Gram Panchayat is Polba.
Police station.
Lordship, I'll just the police station of the Gram Panchayat is Polba. It should be Polba, Lordship. I'm just checking. In a moment, Lordship. PS Polba, Lordship. Polba.
Yes.
Polba. Found it in the deed, Lordship.
Polba, Polba, district.
South 24 Parganas, Lordship. No, district is Chisura. Chinsura, Hubli.
Chinchura.
Hugli.
Hugli.
By tomorrow, stop. The officer in charge / inspector in charge of the said police station shall ensure that the service of the aforesaid articles submitted by the advocate and record of the appellant is served upon the respondents. No, why? They are registered offices at Chandanagar.
Worship, Jarua is what the address is.
Jarura, Jorura.
Jarura.
The taluk is Chinchura Mogra. It's Hooghly, but the police station, my lord, I can't find.
So page 39, if your lordship sees, the land is also P.O. Jarua. If
Jarura, Jarura.
That's the difference. You have to take instruction.
Property is situated within that police station, Pulba.
Yes. Yes.
Service. কি বলেছি? On or before Friday, 8 date দাও. List the matter on Monday, next Monday.
Careful.
Grateful, dear lordship. My lord, it's basically, my lord, Chandanagar police station. I found it out from the net. It's basically Chandanagar.
Pulba.
Yes, my lord. It's basically Chandanagar police station. But we'll attempt from there, my lord, and then if not, we'll come back to your lordship. Grateful to your lordship.
Next.
The 17th is day after tomorrow, madam.
Why?
Because the client has taken all my briefs and had engaged Haradhan Banerjee. I am told that Haradhan Banerjee will submit the case.
No, you do the case.
Then people have dare me to place the plaint copy of plaint.
Anyhow, day after tomorrow.
Man, plain resignation, nothing.
Anyhow.
কি নাম বলতো কি নাম বলতো Yes.
Yes, call. Yes, dismiss for default.
No, I have this is not for my lord. I'm here.
You have not responded. Why?
I'm asking is it 24 or 23. But that matter, you also asked me to what is the record of right? Whether my client, the appellant's name has been recorded in the record of right or not. Well, brief test is high. But can you give some time, my lord? I thought bring my brief. Why I was
Bring.
I'm coming.
Let's call the next.
No, 26, ma'am, for the appeal.
What is this?
Malad, the plaintiff is the appellant before my lords on
Obviously, title suit.
judgment of affirmance,
Title suit for declaration of title.
declaration of title.
Whenever he appears, think it that it is a title suit for declaration of title. Erroneous ROR.
No, Malad,
Not this case.
no, not this case.
All
Erroneous.
your cases are there. Title erroneous ROR.
Malad, here, Malad,
What is the defect?
the first defect, Malad, the name of the persons, Malad, are not matching with the trial course degree and the appeal course degree.
Whose report?
Malad, the names of the parts, that is, Malad, the,
Appellant numbers 2 and 4.
yes. Malad, 2 and 4, name of the 2 and 4 of the plaintiff, not telling with the appeal course degree.
Even with this.
And Malad, upon the,
Even with the cost title also.
the cost title, Malad, we have, yes, Malad,
Number 1 and 2. Umed Sharma and Uman Sharma.
Umed Sharma and Uman Sharma is the, Malad, the right name.
Yes.
That is the right name, Malad. Appeal course degree is, Malad, the drawn up, Malad, the wrong. According to plain,
The name of the respondent number 1 in the certified copy of the decree on appeal does not tally with that of a trial court.
Malad, the trial course is right. Appeal course is, Malad, there is a mistake.
Defendant number 7 in the decree of the trial court does not find place in the decree of the lower appellate court. Whether he died.
Malad,
Defendant number 7. He was there in the trial court, but is not there in the appellate court.
not duly short.
Appellant number 3.
Malad, the 3, Malad, the expert, for that reason, I have, Malad, taken out an application. Malad, after
So-
passing of the, Malad, before filing of this appeal,
You have to.
Malad, I filed an application under for bringing on record the leave to prepare.
That is required under the law.
Malad, that I have filed.
Where is the application?
The application is can
You
one.
have to seek a leave, and it does not require any affidavit or the verification.
Malad, I have filed one application can one.
What is both the courts have gone against you?
Yes.
What is the case about?
Malad, the fact is that, Malad, I purchased the land from the original land, transferred this case land in the year 1962. Malad, I produced the certified copy of the deed of 1962.
Produce the?
Certified copy of that deed.
Yes.
Now, Malad, since the certified, now, Malad, the witness, Malad, from the registry office came, they said, this is the certified copy issued from their office, but the document is not available. In one hand, they said, this is their certified copy that is issued from their office. And Malad, they said that this is not available at present. Now, Malad, both the courts below, Malad, disbelief, Malad, did not, Malad, accept. Since it is a certified copy, I failed to produce the copy. The certified copy is admissible evidence, Malad, that was.
Where is the judgment?
Malad, that is, Malad, recorded in the Malad, the judgment. That is, Malad, in.
Where is the judgment of the apex court?
Regarding this.
That certified copy.
Malad, we have produced this judgment of, Malad, our honorable courts. That is recorded in the order by in the trial court.
So why he has not accepted that?
Malad, since the person concerned from the registry office came forward and says the record is not available, that is the main contention.
What is the view of the Supreme Court in this regard? Where show us that portion. Show us that portion.
Kindly comes to appeal court judgment, page 12, internal page 12. On the middle portion, to that effect, the plaintiff summoned PW2 to bring the volume copies of the two deeds for the year 1962.
Line about?
One of the more or less
Page 12.
page 12.
Yes. To that effect.
To that effect,
Yes.
the plaintiff summoned PW2 to bring volume copies of the two deeds of the 1962. One of them was above mentioned, and the second one in the exchange deed executed between the Shovan Mullah and Shambhunath Bosar, who who was the transferor of Usharanjan Ghosh. In the first day that is 26, 2006, PWD2 disclosed that both the volumes could not be traced out. Now Malad kindly comes to their further the further examination in chief. That is Malad the written in Bengali. The bottom portion. আমি আজ তলব মতো 1962 সালের 71 নম্বর ভলিউম এবং 1964 সালের 94 ভলিউম নিয়ে এসেছি। নেক্সট পেজ 1962 সনের আলুপি ডিস্ট্রিক্ট রেজিস্ট্রি অফিসে রেজিস্ট্রিকৃত বুক নম্বর সাচ অ্যান্ড সাচ লিখবো বুক ভলিউম নিয়েছি। এই সার্টিফাইড কপিটি আমাদের অফিস থেকে বুক ভলিউমের সার্টিফাইড কপি। দলিলের দাতা
So on that day, she could not or he could not bring.
Yes.
That particular relevant volume.
But he says
that is a certificate copy issued by his
issued by the office concerned office.
Correct.
Then দলিলটি বিক্রয় বলা আমাদের অফিসিয়াল কোর্স অফ বিজনেসে এই ভলিউম মেনটেন হয়। আমাদের অফিসিয়াল বিজনেসে ভলিউম মেনটেন হয়। এক্স ফর আইডিসে মার্কযুক্ত দলিলটি সাক্ষীকে দেখানো হইলে তিনি তা ভলিউমের সহিত কম্পেয়ার করিয়া দেখিলেন এবং বলিলেন এই সার্টিফাইড কপিটা আমাদের অফিস থেকে ইস্যু করা হইয়াছে। সার্টিফাইড কপির সহিত ভলিউমের কিছু অসামঞ্জস্য পাইলেন, বলিলেন ভলিউমের হুবহু নকল সার্টিফাইড কপিতে নেই। তোমরা the volumes which were produced on that day and the certified copy, he one and said that the certified copy issued from their office and that was not traceable in the previous page. Now the learned court, appeal court, the learned both the courts below the held that there is some in the bottom portion says ভলিউম নাম্বার সাচ অ্যান্ড সাচ পাতার কোনো অস্তিত্ব নাই। সাক্ষীকে এ বিষয়ে জিজ্ঞাসা করাইলে তিনি বলিলেন এ বিষয়ে কিছু বলিতে পারিব না, এ সমস্ত অফিসের পিওনরা রেডি করে, আমরা শুধু সাক্ষী দিই। তাহাকে সাক্ষী বিষয়ে জিজ্ঞাসা করিলে তিনি বলিলেন আমার বয়ান মিথ্যা। সিন্স হি সেড আমার বয়ান মিথ্যা, নাও the learned first appellate court said that he should be punished under the provision of the Indian Penal Code. And before the appellate court, I filed an application order 4127. That was not considered by the appeal court. That part that dealt with at page 18. Page 18 bottom portion. Lastly, let me consider whether it is possible for the plaintiff to crave out their case regarding their chance of adduce additional evidence under Order 41 Rule 27 of the Code of Civil Procedure. The general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. The conditions are if the evidence in question is tendered in the lower court but was improperly refused in spite of due diligence, appellate court requires. I don't find any applicability of the first two clauses admit additional evidence from the appellate as the trial court record suggests. Now the next paragraph, this judgment was cited before the trial court also. In the same player, the while deciding the case of Srimati Arati Mondol versus Bhupati Mondol reported in the year 2009 Calcutta 200, the Honorable High Court while observed that the party referring the first appeal produced some documents at this stage trial court never tried to. No, Mala, this is the
No, this is
no,
something
this
different.
This is different, Mala. Regarding the certified copy, Mala,
What was that copy which you want to rely as additional evidence? You have already filed a certified copy.
yes, yes.
So what do you want to rely as a additional evidence?
So that copy,
But
that
that
was
is already marked exhibit.
that is marks for X for identification, not exhibit.
Oh,
Mala, that is
this deed was marked as certified copy was not marked exhibit.
no, that was not X for identification.
So improperly, that's the first ground it is there, improperly refused.
Now, only one thing, the person concerned from the registering authority says that the copy has been issued from their office.
There is the judgment of the Supreme Court on a certified copy. Now there has been a shift. It says that it can be used as a primary evidence.
That is. Kindly see the internal page of the trial court judgment. Our honorable court judgment was produced before the learned trial court.
For what?
The certified copy is admissible in evidence.
Or who says not? Whether as a primary evidence or as a secondary evidence? The question is this. Of 6B. Sorry, registry authority say that it should not. But he cannot reconcile the option. There was some confusion. That he says that certificate copies that are prepared by the police and the other staffs. That's the important question. Yes. What to be cross-examined? So what he said was that regarding this module says that everything is prepared by the office peon. They prepare it. And I was only come to do that. This is what that witness says. And thereafter, then the court asked him, then whatever you are saying, because it is prepared by your office peon, then whatever you are saying is false. Then says that yes, it can be said to be false, which is considered that he has come to give a false evidence. But it is in that perspective, whether it is prepared by me or prepared by him, that he says that it prepared in my office, because he says that this certificate copy is issued from our office, and so this is how he interpreted it. Secondly, a important one. The case is based upon this these two documents of 1962. He wanted the certified copy to be marked exhibit. Very interesting because it was not marked as an exhibit. When he's estimating the law on Order 41 Rule 27, very interestingly, if you come to page 19, there are four principles, three principles. One is if the evidence in question was tendered in the trial court but is improper. This is really a case because certified copy ought to have been received. Improperly received. Then he says, I do not find here the applicability of the first two clause. How? The first clause is applicable. It was tendered, but not now. This is the big case. At least the admission is clear. Grounds.
मतलब ground floor मतलब ground number 4 मतलब whether the learned judge of both the courts below substances are in law by not holding that when a part of the document is destroyed, the remaining part is not.
Judge. Okay. Or what?
मतलब 6 and 8 also मतलब that was not considered.
No, this is not a case. First ground is that the court has wrongly held that you do not come under the first category of Order 41, Rule 27. Because you tendered that particular certified copy and it was improperly refused to receive in evidence. So it's a case of a first category.
मतलब that is मतलब the ground number 7 मतलब that where not is written, but मतलब whether learned the appeal court below and not allowing the plaintiff to adduce additional evidence that.
No, he's holding that first ground. Actually, your case is a first ground. Certified copy, when you have proved this and they say that it is a certified copy issued by my, then it ought to have been marked as an exhibit immediately. So it was improperly refused. The appeal shall be heard on the following substantial question of law. First, whether the court of appeal below substantially erred in rejecting an application under Order 41, Rule 27 of the Code of Civil Procedure on the premise that the documents ought to be adduced by way of an additional evidence was not improperly refused by the trial court, thereby ignoring the fact that the certified copy of the certified copy of the deeds executed and registered in the year 1962 was tendered in evidence and corroborated by a witness called from the concerned registry office. Two, whether both the courts below that's the only point. I don't think so. There is a notice special messenger cost within a week from date. Requisite within a week from date. The preparation of paper books on or before the last day of the month of January 2024. Baki orders. Yes. Item 24. This,
Last occasion, the one on 3rd December, the matter was heard by your lordship because the trap power in that. And your lordship to produce the recorder right. Where's the recorder right? That was not with me. I took time for submitting the
whether
recorder.
this record of right was produced
Petition.
before the trial court.
Yes, yes, that was produced. Definitely. Exhibit this second. কোথায়? Exhibit list হবে। আমি তো দেখতে পাচ্ছি।
You are not ready.
No. No, your lordship asked me. Yes, it's record right. Yes, yes. Certificate arrest Kotian, 70 exhibit. Record right. Yes.
What is the matter about? We
Yes, yes,
forgot.
yes, yes. Series of record right. 385, 384, and 55, 534, 535. কোথায়? Copy error Kotian. This is on page 5 exhibit. Page 5 of the appeal court. No, trial court. Page 5. Exhibit 13, certificate copy of LR Khotian. Exhibit 14, series of
Khotian is different.
LR Khotian. In every plot, there is a LR Khotian.
LR.
Yes, LR.
Under,
In the LR.
Under RS, LR Khotian.
LR Khotian.
Under RS also.
No. RS also, Khotian is there.
So,
obviously there is a Khotian.
LR Khotian, then you say, why you qualify as LR Khotian?
Land reforms Khotian in every plot, there is a.
Even prior there to Khotian was there.
Your losses, no, yes. Now, Khotian.
One man, one Khotian.
Is in the family. The family, there are, in the family, they say that the plot.
All his properties would.
Yes, yes, yes. One. Can you see? This is the Khotian, and this was the exhibited. One man, one. Page 5, trial court.
Yes.
But first, Kobir Kumar Sadhu.
Riot.
Khotian 535, 534. 534. Stop. In Bengali, my lord.
Yes, 534.
Well, probably one of your loss is the Bengali literature, my lord. But can I translate it? Then I can give me time. Otherwise, I cannot. I can translate it. Then your loss can understand in Bengali, in our language. Yes, my lord. Plot number 685713. Next also.
Dark number is
685 7
number. This is the Khotian. This is
yes.
Yeah.
Oh, top Khotian. Dark number 685 713. And this is the suit plot.
The plot number is
685
685
713.
713.
Next also same, but Khotian 536. That is Onimes Pal. Here's all the plaintiff.
This
What is the
is
plaintiff?
Onimes Pal.
Yes.
This is
Amade.
Onimes. Same Abhay. This is the Abhay Padu. Here is the Abhay Chandra. Adhar Chandra.
Then Tapan Sen.
Abhay
Tapan Kumar Sen
Madhu.
is another plaintiff. There are three plaintiffs.
So theme is 685 and 713.
Yes.
Shali.
It's completed, my lord.
And Khatiyan number is 536.
Yes.
In name of Animesh.
Animesh.
And then 535.
535.
In name of Tapan Kumar Singh.
Tapan Kumar Sen.
Tapan Kumar Sen.
Yes.
And this is the same one is
Khatiyan 535.
685 713.
Yes.
Yes.
Only that your lordship asking me to produce the record of right. Oh, doesn't it here? Yes. Very good of it.
And then 385 again. Khatiyan number, next page.
535.
Then 385.
Yes, 535. The next.
No, 385 is
Oh,
the next.
385, that is the vendor of the plaintiff.
This is
Keshav
the-
Chandra Singh.
This is the Keshav Chandra Singh.
Yes.
Keshav Chandra Singh. Yes. 713.
Yes. That is, they sold the property in favor of the plaintiff.
Oh.
We purchased. The vendor.
Correct.
Tandon Kumar Singh is vendor.
Chandan Kumar Singh is a
Vendor. Sujit Kumar Singh is a vendor.
Chandan Kumar Singh. Now, Chandan has 685 and 713 both.
Yes.
But Keshav has only 713.
Yes.
And this is a Ojit. Sujit.
Sujit.
Sujit Kumar Singh. Singho. Yes, 685 and 713.
That's the one. We purchased from them.
Anyhow, let us come because I don't know. There is one meeting which is fixed at 4.
There is a come back
Administrative meeting.
tomorrow.